Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the criminal motions calendar for July 24th, 2024. I'm going to call the calendar and we'll await a response from the attorney or from the defendant if and the state if the defendant's attorney is not present. First on the calendar is Kiera Simone Archie. That's Ms. Kurt. It's my understanding Ms. Kurt has a leave of absence. Is that correct?
Yes, ma'am. We've got to reset that, Judge.
All right. Next is Kiara Shanice Beatty. Ms. Beatty's case has been closed. Any need to revisit that?
None from the state.
Okay. All right. Renika LaShun Bird.
For
Lister Holton Dennis.
good morning, Your Honor. This is Attorney Taylor. I'm in the courtroom. Ms. Bird is present with me in the courtroom, and I just asked for some time to have a conference with Ms. Bird and explain the situation to her.
Sure. This is on a motion to revoke bond. Is the state ready on that?
The state would ask for a brief hold. Both of the officer and the victim are served and indicated that they would be here today, so we're just asked for a hold to see what's preventing them from logging on right now.
Okay, someone else just logged on, so maybe one of the people you're waiting for. Also, ladies and gentlemen, I see one person maybe who has not logged on with their first and last name. That's essential for us to keep track of who's here on the call. So if you see a phone designation or a computer designation, please put your first and last name. You put your finger or your cursor over where you are, where you see that phone designation. When you click on that, there should be a menu that comes down from the side, 3 dots in a blue box. Click on that. When you click on the 3 dots in the blue box, then it should pull down rename and click on that, type into the box your first and last name, hit save, and that will change the name on the screen. Okay. So you're looking for a rename function. All right, that's fine. Someone has indicated that they're having technical difficulties. Ladies and gentlemen, if during the process you have to log off and log back on, that's fine. Just let us know when you come back in that you missed some portion of it and that you had technical difficulties, okay? And we'll catch you up. All right, next is Raquan Lamar Monte Dixon, motion to revoke bond.
Your Honor, I know you can't see me. I'm the one who's having technical difficulties. Good morning.
Yeah, but I see the nice plant and the wall.
Your Honor, I apologize. I may have to log back in or join from my phone. But I spoke to Mr. Dixon. We had not made contact prior to today. And Your Honor.
Okay, so you said you spoke to him, but you hadn't made contact. So that's somewhat contradictory. Clear it up for me.
Yes, Your Honor, I apologize. So I've spoken to him this morning since he's logged on the Zoom, but I had not been able to speak with him in order to prepare for the motion. I've spoken with him briefly, so I'll need to speak with him some more to prepare.
So you want a breakout room?
Yes, Your Honor.
All right. All right, the next case is McKay, Robert Lee McKay. It's MCCAA. Mr. Holton Dennis, motion to revoke bond.
Your Honor, I've attempted to make contact with Mr. McKay. I've called the bonding company and have not spoken with him.
All right. Then if the state's ready, we'll go forward. There's no indication that he didn't get notice.
And Your Honor, for the record, the defense would object to moving forward with the hearing, but I understand.
On what grounds?
Your Honor, I believe that the appropriate remedy would be a bench warrant and to have the hearing when he appears.
Either way, a warrant's gonna be issued. Especially if we have the hearing and I find that there's reasons to revoke. So you're saying just go ahead and get him arrested anyway and then have the hearing. That works for me. State have any objection?
The state is ready, but given that we don't necessarily know if there was exact notices given out, the state would just have no objection with just issuing the bench warrant bond forfeiture and having the hearing when he's in custody.
Well, let me ask this before we release all these good witnesses that we have that have made time to be here for both sides. Is there any indication from the clerk's office that Mr. McKay was not served? Y'all let me look at that and let me know. Dana
Your
Reeves?
Honor,
Yes.
this is how you doing? This is Officer Karen. How you doing, man?
Hey, Officer Kearney, how are you?
Doing great, doing great. I did check up. He is wanted out of Clayton County for some code enforcement violations also.
So he already has a pending
Warrant, yes, ma'am.
Okay. All righty. Dana Reeves?
Your Honor, that's going to be a plea,
Okay.
and she should be in the courtroom.
Your Honor, Ms. Reeves is in the courtroom.
All right. So, Ms. Hahn, I see very clearly and hear very clearly. What is preventing you from being on the other side of the camera?
Your Honor, I'm not sure. Oh,
There you are.
Your
See
Honor,
these filters. When we put these backgrounds and these filters, they had you on the other side of the background. You were
Your Honor,
behind-
I'm so sorry. I don't know, I had been messing with the little thing that covers your camera, and I guess I switched it too many times.
I was supposed to be the young people.
For-
Technology.
For Ms. Reeves' plea, I do need a moment to be able to amend the accusation for the correct plea to go through.
That's fine. DeVarsity Darquez Smith.
Your Honor, Mr.
He's on the
Smith. Oh,
call. He's on the phone. He's on here.
yes, Your Honor. I need a minute to speak with him. I hadn't made contact with him prior.
All right. I'll put you in a breakout room at the appropriate time.
Thank you.
Sierra Shante Telfair.
Your Honor, Ms. Telfair, it's on the call. I need a moment to speak with her as well.
I'm right here.
All right, I'll put you in a breakout room at the appropriate time. Okay, so it looks like all of the cases on here are motions to revoke bond. There's one case that has been announced as a plea. There are several where folk need to talk, and it's my understanding that we're ready to go forward on the Bird case. Is that correct, Mr. Taylor? Oh, no, I'm sorry. You need to talk too.
I need to speak with her as well.
All right. So Bird is in the courtroom. Reeves is in the courtroom. Smith is on video. Telfair is on video. Dixon is courtroom? No, video. All right. All right. So I'm going to set up the breakout rooms. Mr. Taylor is going to speak with his client, Ms. Bird, who's in the courtroom. He speak with them directly. So I'll set up the breakout rooms. Ms. Hahn is going to speak with Dixon, then Smith, then Telfair.
Yes, Your Honor.
Excuse me, Judge.
Yes, ma'am.
Yeah, on Mr. McCaw,
Yes.
I show that there was a notice emailed to him, not U.S. postal mail.
We're doing that now?
Apparently so.
Okay.
That's what
And that's
CPUA
the-
shows.
Okay.
Maybe
All
it
right.
was sent in the mail too, because it says notice emailed and notice printed.
Okay. So that's possible that he got both. All right. So give me a moment. I'm going to let Ms. Hahn talk to her other clients. I'm going to let the state amend as necessary on Reeves, and Mr. Taylor will talk with Ms. Bird, and then we'll be back to go down the list.
Thank
All
you.
right, if y'all have any cases where your witnesses need priority, work that out. And then when you come back to me, I'll do whatever, which one we want to do. All right, I'm going to put Miss Dixon or Mr. Dixon, I'm sorry, in the breakout room with Ms. Hahn. Ms. Hahn, I'm going to put you in breakout room number 1. And let's see, why am I having trouble finding Dixon? There you go. Raekwon Dixon, breakout room number 1. When you all come out of the breakout rooms, then I'll take a report, and then we will go ahead and continue. Now, for the person who is listed as iPhone, please go ahead and rename yourself to your actual first and last name, because I don't know who you are otherwise. Okay. All right. Thank you. I'll be right back.
Mr. Dixon, we can go back in the breakout room. I pressed leave before you were asking me a question.
Oh, okay.
And Your Honor, this is Attorney Taylor. Could we have the person on the Zoom call that's LGELM K500 update their name?
I think that may be Mr. Mormon, which is a victim on the case. He just doesn't know how to update his name.
Who is
Having
that,
trouble doing it.
Ms. Payne?
Abe Mormon
Abe
from Miss Bird's case. I
Certainly.
believe that's who that is.
Then that's fine.
Your Honor, I have an announcement.
I'm sorry, go ahead, Ms. Hahn.
Yes, Your Honor. So after speaking with Mr. Dixon, again, like I said, this is the first time we've been able to speak since being notified of the motion. Mr. Dixon is asking for us to continue the motion to revoke to the next motions calendar. Based on
Why
the
would I
fact
do
that
that?
he's let me, I'm sorry, Your Honor.
Why would I do that? He's supposed
Your
to be
Honor,
in
he's let
court
me-
because all of these motions to revoke are supposed to be in court. So, okay.
Yes, Your Honor, I'm aware, and had I been able to speak with him, I would have told him to be in the courtroom today. But Mr. Dixon has let me know that there's potential witnesses that I would have needed to subpoena for today, potentially even an alibi witness, and I think that have we had the chance
So
to?
this notice didn't just go out. Why is Mr. Dixon just telling you that he has witnesses that could speak on his behalf? This is a battery case, so I'm not inclined to push it any further out. Notice was given a while ago.
Yes, Your Honor.
These cases weren't immediately scheduled like we normally would.
Yes, Your Honor, I'm aware.
The state would also object to it because we have both of our witnesses here, and it's actually a motion to revoke bond based on two separate cases since this case, and he's actually wanted on one of the new cases.
So yeah, that's a no.
Yes, Your Honor. In that case, Mr. Dixon is going to be accepting the state's offer. It's going to be a plea on the case that's on the calendar today, especially in light of the fact that we believe we have a strong defense on the other cases. I just need to confirm with Ms. Payne just one issue, and then it should be a plea.
Is the state dropping the motion to revoke in exchange for the plea?
Yes, Your Honor, we would be.
All right. All right. So I'll give you a moment to talk to Ms. Payne. But first, you need to speak with who?
Ms.
Smith
and Ms. Telfair.
Okay. Okay. So I'll put you in a breakout room with Smith.
Thank you.
All right. So Mr. Dixon, for some reason, is still in that room, and I'll put Mr. Smith in room 2. I'm gonna move Miss Han to room 2. All right, we'll be back.
Mr. Smith, please join the breakout room. Mr. Smith, please join the breakout room and just be cognizant that we are in court. So please conduct yourself as if we're in court and join the breakout room. So, Mr. Smith, do you know how to join? The judge has added you to a breakout room and I need to speak with you. Can you please join breakout room? Thank you. Your Honor, I have an announcement for Mr. Smith.
Yes, ma'am. What's your announcement, Ms. Hahn?
Your Honor, we're going to be moving forward with the hearing.
Okay,
And then lastly, I just need to speak with Ms. Telfair.
okay, Ms. Telfair, I'm gonna put you in a breakout room with Ms. Hahn. Okay, is Mr. Smith gonna ever come out of the breakout room? Like, Ms. Hahn, can you tell folk that they can come out of the breakout room?
Yes, Your Honor, I'll tell him again.
All right, so I'm gonna put Miss Telfair in breakout room number 2, and while y'all are in there, y'all can help Mr. Smith come out of the breakout room.
Yes, Your Honor.
All right.
Mm.
Judge, if you have a moment, this is Attorney Jonathan Oberman on behalf of Michaela Joyner.
Yes, sir.
Judge, we on the counter for 11 o'clock. However, we had actually withdrew our motion to suppress. So I just wanted to make sure that the court received that. We withdrew it last week, just for the court's record and see if we can be excused.
Okay. If there's no objection from the state, all right, that's fine with me.
All right. Thank you, Judge.
You're welcome. All right, so Joyner, that motion has been withdrawn. All right, I'll guess, oh, they're not back yet, okay. Thank you, Ms. Wright, for the clarification.
You're welcome. Do I need to clarify for everyone in the room?
No, we're good.
Good morning, Your Honor. We believe we have a resolution to Ms. Renika Bird's case.
All right, we have a plea.
We do have a plea, Your Honor. We have a plea agreement with the state.
Okay. Solicitor Payne,
Yes, Your Honor.
when you're ready, we can take the plea for Bird while we're still waiting for Ms. Hahn's case.
I'm ready, Your Honor.
Okay. All right, bring Ms. Bird up to the computer.
Thank you, Your Honor. This is Ms. Bird.
Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus Renika LaShun Bird, 2023 CR 10534. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Taz Taylor is with you at the podium. And Mr. Taylor, your client is charged with battery, count 1 by provocation, and simple battery, count 2. What does she plead to the offenses before the court?
Your Honor, Ms. Byrd is pleading guilty to the offenses.
Okay. All right. Am I entering a plea of guilty to counts 1 and 2, or is one of them going to merge?
Ms. Payne, I believe they merged, but I'm not 100% on that.
Yes, Your Honor, 2 would merge into count 1.
All right. So by entering a plea of guilty to count 1, count 2 will merge. You you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yeah.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about June 18th of 2023, officers did respond to 5013 Courtney Drive, which is Efficiency Lodge in Clayton County, Georgia, and made contact with Ms. Katoria Menfield, who stated that she was punched several times in the face by the defendant, and who also threw her to the ground, and the officers observed swollen nose and abrasions on her knee. And all this occurred in Clayton County. And the recommendation for the plea is for count 1, 12 months to serve 120 days jail, balance suspended upon her having no contact with Miss Katoria Menfield, and count 2 would merge into count 1.
All right. So you said 120 days in jail?
Yes, she has a battery from 1999, a battery family violence from 2016, and a battery family violence from 2018 that she's pled guilty to.
Mr. Taylor?
Yes, Your Honor. We agree with the state's recommendation. However, we do wish for the sentence to be served on weekends, and we've discussed that with the state. Ms. Byrd, it's okay, we're up here. Ms. Byrd has minor children, which she has to care for. In addition, she is currently on felony probation, where she is reporting weekly and doing drug testing every week, taking mandatory AA classes, and participating in a DRC class every Tuesday, which confirms her attendance at the AA meeting classes before, or the AA sessions before she can attend the class. And she's also enrolled in and beginning to participate in the Potter's House outpatient program. We feel that if she is allowed to serve her sentence on weekends, she can continue to participate in the probation and in mainly the drug testing and the drug classes, which would be a benefit to everyone involved.
Okay, so Miss Menfield, how is Miss Menfield known to Miss Byrd?
The two parties, I don't believe they know each other. It was an incident that occurred, an altercation between several parties at an apartment complex.
So is this a substance abuse issue, or are we dealing with dealing with something else?
The particular instance was not related to any kind of substance abuse. It was an argument or of some sort between multiple parties. Ms. Byrd is accused and does stipulate that, or does admit to having physical contact with the alleged victim, or the victim in this case. However, the victim immediately afterwards went to her car and pulled a gun and shot at Ms. Byrd. This wasn't a situation where Ms. Byrd was acting randomly, but she doesn't know the victim and does not anticipate any contact going forward.
Ms. Byrd, you seem to be where all the problems are. I don't know if it's you not, I mean, like, what's going on? How old are your kids?
I have 9 children, ma'am. My youngest is 4 and 10 and 13.
And who's caring for those children?
Me. And I will, if you allow me to speak on this, I do struggle with alcoholism. It's been a struggle with me for quite a while. Majority of these incidents occurred when I was under the influence. That's why I went in and got myself enrolled in inpatient, because I'm trying to better myself. I really am.
Okay, can I ask you something?
Yes, ma'am.
Do you intend to have any more kids?
No, absolutely not. My baby's 4. No, ma'am.
I mean, that don't mean nothing. You got 9, so you got a proven track record of fertility. I'm just saying your kids deserve to have a mom who's not always under the threat of going to jail. And as long as you're on probation or parole, you have the possibility of going to jail. When they tell me 120 days, but Judge, I want to spend it on weekends, that's like 60 weekends. That's more than a year of going to jail every weekend. So when are you gonna spend time with them babies? Miss Bird, that's why I'm asking. I sort of was kind of asking if there was maybe a mental health issue that needed some attention because
Okay. I'm sorry.
go ahead, tell me.
They did give me a mental health evaluation, and they did diagnose me with post-traumatic stress disorder that I take medication for, yes.
Okay, I got you. All right, so that is a little bit clearer. And I'm glad that you are in the programs that you're in, even if they're court ordered, because at some point you got to take control of your life. Okay, and the reason that you have to take control of your life is that A, your life is not over and it deserves to be better, but you have kids and your youngest is 4, and that they don't deserve chaos and instability. That's the worst thing you can do for a child. You talk about PTSD, you want to cause PTSD in developing children, you make their world chaotic and unstable.
Right.
And so when you put yourself in a situation where somebody could go to their car, you could not be here right now. That was not a situation you needed to be in all the way around. That's one of those mind your business, stay in your room situations.
I agree.
But you could have taken yourself completely away from your children. I'm one of those people who's hard-headed enough to believe that no problem that you're faced with is insurmountable with the right direction and the right motivation. But you got to make your kids your motivation, because you, at the time that this happened, you would have had a baby. That 4-year-old was a baby, and you putting yourself in a situation where you could potentially get shot. The next time you decide you're going to pop off about something, that you're going to get hot-headed, that you're going to go forward instead of walking away, remember that if something goes way left, who's taking care of your child? Who you got lined up to take care of these kids? Let's talk about that.
Nobody.
No, that's not the time to fall apart. We're having a pragmatic discussion. This is practical stuff. If you are not here, who's taking care of the 4 you still taking care of? And it's not fair to put them on the other 5 that you have who are already trying to get their lives together. Who's taking care of the 4-year-old? Who's taking care of the 9-year-old? Who wants to take on all that responsibility? I am a fan of people bringing children into this world and raising them properly, which means giving them stability and love, whether that's in a single parent household, or because I was raised by a single parent, or whether that's in a family with 2 parents. I don't care what they look like if they're giving stability to these kids. But what I'm telling you is we keep bringing kids into situations that they don't deserve. We just having babies, and then our life is unstable. And that means their life is chaotic and unstable. And so you're putting yourself in a situation where somebody could have blown your head off because you got mad and participated in an argument. Who was going to take care of them babies? Name 2 people you trust to take care of them like they should be taken care of.
My mom is deceased.
The what?
My mother is deceased. I have older kids.
Okay, well, they don't deserve to have to be an instant parent. I'm gonna tell you that right now. You chose to have kids, they didn't. You got me?
Yeah.
So you need to preserve your life and sanity so that you can take care of these kids that you decided to bring here. Bringing 9 babies into the world is a conscious decision. And so when you make that decision, you make the decision to bring them in a situation where they're going to be stable, where they're not going to go out and commit these same offenses, where they're not going to spend 120 days in jail. So you need to get your life right.
I know. I'm working on it.
The next time you think about slipping, you better call up a picture of that 4-year-old in your head and imagine what happens when DFACS has to take care of them because you're not here. I mean, all the crying in the world ain't gonna change the situation you're currently in. I mean, sometimes crying is cathartic. Do it if that's what you need to do. But what I need you to do is once you finish crying, I need you to girl up and get your life straight. Because nobody else is gonna do it. And even those people who say, well, you know, my mama would take care of my kids. Your parents don't want your kids. They have already raised kids. They don't want yours. I'm gonna tell you right now. They want to be on cruises. They want to be sitting in their garden. They want to be shopping at discount stores. That's what grandparents want to do. They don't want to raise another set of kids. These kids are different. All right. So I'll accept the plea because Mr. Taylor seems to think that you can do it. And I don't have a dog in this fight one way or the other. But what I will tell you is if you mess up, you coming back to see me. And if you mess up, you're going to fail your kids. Now, coming back to see me is the least of your worries. Failing your kids is the most. You got me?
Yes, ma'am.
All right. So I'm going to accept your plea of guilty to count 1. Count 2 will merge. I'll sentence you to 12 months to serve 120 days on weekends. And I'll put you on probation so that you're that's monitored. After the service of 120 days on weekends, you'll turn yourself in by 6 p.m. on Friday, and you'll be released by 6 p.m. on Sunday. Make whatever arrangements you need to make for your kids for the next 60 weekends.
Okay.
Holidays, birthdays, you show up or you coming back to speak with me. We're clear?
Yes,
The
ma'am.
last thing you want to do is spend 120 days straight in the Clayton County Jail.
Mhm.
All right?
Thank
So
you.
you'll come every weekend at every Friday at 6 p.m. Until you have completed service of your 120 days. You're to have no contact with Katoria Menfield. You're to have no violent behavior during the course of your probation. Do you understand?
Yes.
Any new offenses that you pick up, you coming right back to see me, and you have to worry about your felony probation. So you're on a real tight string. You're on a balance beam. You better be Simone Biles, because if you fall off that balance beam one way or the other, your children are going to suffer. We clear?
Yes, ma'am.
All right. So when you leave the courtroom, you're going to go to the right. Once you exit, you're going to go talk to Ms. James, who is our probation expert. She's going to explain everything that you need to know. You're going to be on probation until such time as you complete all of your days to be spent. And the reason you're going to be on probation is because of the need for supervision. Now, this is the only issue that I have. She's probably going to need to have both count 1 and count 2, because if she's going to do 60 days, that's going to be outside the 12 months. So she's going to have 2 run consecutive with count 1 so she can complete.
Yes, Your Honor, we just ask that once the 120 days is completed into the second year, that probation terminates.
That's okay. Yeah, I'll allow probation to terminate.
Thank you, Your Honor.
All right, go see Miss James. Thank you. Hold on just a second.
Your Honor, before she leaves, Mr. Mormon, which is the victim on the second case, is on and was wondering if he could just make a statement.
Just one second.
Okay. 'Cause 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 'cause
All right. Where is he? Mr. Mormon, is it?
Steve Mormon, I don't think he ever changed his name. I believe he is the LGELMK 500.
Okay, for the person who is LGELMK 500, is that Mr. Mormon? Okay, I can't hear or see you.
If he stepped away, I was just informed by the victim advocate that he requested to make a statement. But if
Okay.
he's not responding, then he's not
Yeah.
responding.
All right. All right. Remember what I said, Miss Bird. Your kids don't have time for you that to get it together. They need you now. So make the best effort that you can to be the best mother that you can, and don't have any more babies right now, ma'am. I don't care if people get mad at me for saying that. You take care of the ones you got. We clear? All right. Go outside, speak with Miss James, take a left, count 1 and count 2 will run consecutive, and then we'll move on from there. All right. So you have an announcement for me, Ms. Hahn?
Excuse me, Judge, I'm
Bless you.
sorry.
Yes, ma'am.
Is her jail time to start this Friday?
Mr. Taylor, she's starting this Friday?
Yes.
Yes.
Ms. Bird indicates she can start this Friday.
Thank
Yes,
you.
ma'am. Thank you.
Thank you.
All right. So we have pleas for Dixon, Reeves, and hearing for Smith. And what's the announcement on Telfair?
Your Honor, that's going to be a plea, but she just needed to go back in the breakout room for me just for a moment. At some point, she dropped her computer and it went out. So
Okay, just 1 second. Let's go ahead and take care of these pleas for Dixon and Reeves.
Okay.
Those of you who are on the 11 o'clock calendar, we're getting there. We should be able to call the calendar in a few moments. All right, can we get Dixon to the podium?
Mr. Dixon is on the Zoom call. Mr. Dixon, can you please turn your video on and your sound as well, or your microphone? Unmute yourself, I guess. Thank you.
All right, Mr. Dixon, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Mr. Dixon, you're before the court on 2024 CR 02178. Raquan Lamar Monte Dixon, represented by Lister Holton Dennis, Chelsea Hahn. This is on a motion to revoke bond. Instead, you're taking a plea. Simple battery, family violence count 1, and simple battery count 2. Ms. Hahn, what is your client plea to the offenses before the court?
Your Honor, he will be entering a plea of nolo to count 1, and count 2 will merge.
All right. By entering a plea of nolo to count 1, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right. Factual basis recommendation, please.
Yes, sir. On about April 4th of 2023, officers responded to 1018 Gardnerwood Drive in Clayton County, Georgia, and made contact with the victim, Ms. Nia Jones, who stated that the defendant did pick her up several times and throw her on the bed, as well as pushing her whenever she would try to get off the bed. And all this occurred, and they did reside in the same household, and all this occurred in Clayton County. The recommendation is for count 1, 12 months to serve 90 days jail, balance suspended upon him having no contact with Ms. Nia Jones, And for count 2 would merge into count 1.
All right. Who's Nia Jones, Ms. Hahn?
Your Honor, I believe they're partners.
All right, Mr. Dixon, what's going on? Do you have children with Ms. Jones?
No, not at all.
All right. What was the basis of the motion to revoke?
It was another case with it was 2 more cases with Miss Jones, criminal trespass, damage in the 2nd degree, and battery, family violence with Miss Jones from March of this year.
Mr. Dixon,
Yes.
look at me clearly, sir. Okay, what is going on that you can't leave Miss Jones alone?
I don't know how I caught the cases for March because
No, sir. No, we're gonna
Yeah.
change the terminology. You
Okay,
didn't
yeah.
catch the cases like somebody catch a basketball. You went looking for these cases. Nobody took you over to Miss Jones's house and let you catch a case. You went looking for them. And it was in contravention of the court's order that you not have any contact. So by all rights, you should be charged with felonies. What I'm trying to get through to you is just because this is being resolved with a plea and 90 days in jail doesn't mean that it's not serious. You ain't catch no case. You went looking for one. Now, let's continue. What's going on that you can't stay away from Miss Jones and you can't stop treating her in a violent manner? Look at me in the computer. Stop looking down.
Yes, ma'am. I really don't know. It's just everything, like with the situation, everything be cool, okay? It just things happen when people
No.
drink like that.
Let me tell you something, Mr. Dixon, because you're about to give me a lot of who's and what's in and stuff I don't want to hear. Sometimes people can love each other, but they shouldn't be in a relationship together. And clearly this is the case. Love doesn't hurt. Love doesn't push. Love doesn't throw you on the bed. Love doesn't beat you down. Love doesn't catch 3 cases. You gonna end up being one of them cases on TV where it's a murder suicide because you can't let Miss Jones go. And what I'm telling you is your attorney and the state are okay with this plea, but I'm not necessarily okay with it. I still think you should be charged with a felony.
Your Honor, I've spoken.
Ms. Hahn, hold on. No, this young man needs to learn because this is going to be one of those cases. 3 times, same person. And all he can tell me is I caught a case and see what had happened was. The issue is not with Miss Jones. I don't care what she did. The issue is with you. Because if somebody's not treating you well, or if somebody's not in a relationship the way you want to be in a relationship, walk away, find a new relationship. But your inability to do that and you're changing it into a violent situation, the problem is with you, not Miss Jones. She got her own issues. It's with you. And until you acknowledge that, you're going to keep coming back here for violent encounters with Miss Jones.
I understand that.
The last thing I want is to see a television news report of murder suicide. Mr. Raekwon Dixon shot up or killed up Miss Jones. He had been before the judge 3 or 4 times. He ignored all orders to stay away from Miss Jones. So you're playing with me now. I think you should be charged with a felony, and I'm not sure I'm okay with this plea.
Your Honor, this is a simple battery on the first case. Mr. Dixon has let me know, at least on the other cases, as I mentioned before to the court, that there may be an alibi defense, at least in one of them. I do believe that we will be taking at least one of those cases to trial. So we're asking that you accept the plea, Your Honor. Mr. Dixon, he does have children and a job that he's been able to keep steadily. He's explained to me that he's had his children for the last 3 weeks. So he,
well, that's whoever that crazy person is. That don't mean nothing to me. He's still got to do 90 days. Where the children going when he do his 90 days?
I understand, Your Honor. So we did have that conversation. He said that the children will be partially with their mother, and then in the time that would be allotted to him, he would have them stay with his parents until he's released. So, Your Honor, we are asking that you accept Mr. Dixon's plea.
Mr. Dixon.
Yes, ma'am.
Okay, so here's the thing. Let me explain to you what should happen. When you got the second case which involved Miss Jones, you should have gotten a charge with aggravated stalking, which is a felony punishable by up to 10 years in prison, a $10,000 fine, or both. And I've never seen them just give somebody the fine. Once it goes upstairs, especially if you get certain judges, you likely to get a good portion of them years. Number one. Number two, you could also be charged with a misdemeanor, 12 months in jail, a $12,000 fine, or both. In addition to that, having your bond revoked. Okay, whoever's on the iPhone, mute yourself.
Oh, okay.
And have some decorum. We're in court. So what I'm saying to you is the consequences of what you're doing are extremely serious. The problem is the court hasn't caught up with what you're doing. After that second case, you should have been charged with the felony of aggravated stalking. And I keep pushing the police. I keep pushing the solicitors. I want to see some aggravated stalking charges because I'm tired of people coming back with 3 and 4 violent misdemeanors because they keep getting away with it. So please hear me very clearly, because the state seems to be okay with this. Ms. Hahn seems to be okay with this. I'm not okay with this. I think as soon as I sentence you, you do these 90 days in jail, you're going to run right back to Miss Jones, and it's going to be worse. Because I'm looking in your eyes. You ain't ready to give that up. You ain't ready to walk away. Yeah, let's do the motion to revoke. I'm not taking this plea.
Your Honor.
He should have been in court. He already knows. So, and if I have to send county Uber to get him, I'm fine with that too.
Mr. Dixon. Mr. Dixon.
You see, people are playing. They case after case after case. Bond conditions clear as day. Don't do this. Don't do that. Don't do this. And folks keep doing it.
Did he log?
Huh?
Your Honor, if I could, well, I'll
All
need
right.
a moment at some point to call him because
That's fine. Bless his
Drop
heart.
off.
Let him be mad for a minute. We got Reeves. Plea.
yes, Your Honor, that's going to be a plea. She should be in the courtroom.
All right, Ms. Reeves, come on up. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. I can't hear you, ma'am. Speak up.
Yes, ma'am.
All right, you can put your hand down. All right, you're before the court on state of Georgia versus Dana Reeves, 2022 CR 00949. Lister Holton Dennis is representing you. This is a motion to revoke bond, but you're taking a plea for simple battery, family violence, and simple battery, counts 1 and 2. What does your client plead to the offenses before the court, Ms. Hahn?
Your Honor, I believe the state has amended the accusation to include count 3, disorderly conduct.
All right. What does your client plead to the disorderly conduct?
It'll be guilty to disorderly conduct, Your Honor.
All right, by entering a plea of guilty, is it county or state?
My understanding is that it was state. Is that correct, Ms. Payne?
It's state.
All right, by entering a plea of guilty to state disorderly conduct, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to present evidence and testimony on your behalf. You give up the right to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, Ms. Reeves? Ms. Reeves, can you hear me? All right. Factual basis recommendation, please.
Yes, Your Honor. On or about October 25th of 2021, officers did respond.
Okay, I can barely hear you, so it may be because of your turn that way as opposed to towards the machine.
Oh, I apologize. On or about October 29th, 2021, officers did respond to 5013 Courtney Drive, apartment 244 in Forest Park, Clayton County, Georgia, and made contact with Melvin Davis, who worked at the Efficiency Lodge, which was where they responded to, who stated that the defendant came to room 244 knocking and banging on the door, causing a disturbance. So therefore he called law enforcement because she refused to leave. And while law enforcement officer was speaking with Mr. Davis, they did spot the defendant, and the law enforcement officer specifically observed the defendant grab the victim, in this case, Mr. Joseph Stringer, without Mr. Stringer's consent, and all this occurred in Clayton County. And the negotiated plea is just for count 1 and count 2, the state's moving to dismiss. For count 3, it is just 12 months to serve, 2 days jail, credit for time served, balance probated, and while on probation, take an anger management class and pay a $300 fine. And
all right. Is there any connection between her and Mr. Stringer?
Your Honor, they were partners in the past, but no longer.
All right. Ms. Reeves, you understand how seriously I take this?
Yes, Judge.
All right. So I'm going to accept your plea. Are you and Mr. Stringer still dealing with each other, or y'all done?
No, ma'am, we're done.
Okay. Y'all don't have any kids in common?
Yes, we have a daughter.
Okay. How do y'all deal with the daughter?
He does not help me with her. I take care of her on my own.
Okay. All right. If he wants to be involved in your daughter's life, make sure he goes through the Superior Court and gets the proper documents for visitation, paternity, custody, child support. Okay. All right. And visitation. All right. So I'm going to accept your plea. I'll send you to 12 months to serve 2 days, credit for time served. Balance will be probated for you to take an anger management class and submit proof to the probation office, and also to pay a fine in the amount of $300 with the surcharges. It'll be $444. Upon payment of all of those amounts, your probation will be suspended as long as you have no contact with Joseph Stringer other than contact allowed by the Superior Court due to your co-parenting agreement. All right, and that'll be for the 12 months. All right, when you leave the courtroom, go to your right, go to Miss James's office in the next courtroom over, 305, and she'll assist you with getting signed up for probation. The quickest way to get rearrested is to not attend your probation reports, okay? All right, thank you. All right, and Telfair, you needed another breakout with Telfair.
Your Honor, she just had a question for me. She chatted it to me, so we're ready for the plea.
Okay, Ms. Telfair, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Ms. Telfair, you're muted.
Yes.
I'm getting interference from someone.
Hold on 1 second.
Someone interfere, it kind of figure out who that, okay. All right, so Ms. Telfair, you're before the court on 20. You can put your hand. Did I swear you? Oh, you solemnly swear or affirm any testimony you give will be true?
I do, yes.
All right, you can put your hand down. So you're before the court on 2024 CR 03398 for Sierra Shantae Telfair, Lister Holton Dennis. You're charged with simple battery and simple assault. What is your client plea to the offenses before the court, Ms. Hahn?
Your Honor, that's going to be a NOLO to count 1. I believe the state is dismissing count 2.
All right. By entering a plea of NOLO to count 1, you give up the right to have a trial by jury or judge You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
I do.
Factual basis and recommendation, please.
Yes, Your Honor. On or about July 23rd of 2023, Officer Middleton did respond to 10375 Terra Boulevard in Jonesboro, Clayton County, Georgia. He made contact with the victim, Mr. Thomas Green, who stated he was outside working on his vehicle in front of the residence because it had broken down, that his girlfriend's mother asked him to try to help him with jumping the vehicle, and then the defendant came out and got inside the vehicle and started to drive off in the vehicle. All the cables were attached, so he quickly removed them. She then brought it back, and Mr. Green quickly got the key fob out of the vehicle. And then the defendant followed him around the vehicle, arguing with him, trying to get the key fob from him. And Mr. Green stated that the defendant was lunging at him and trying to grab him, and that she actually did grab him twice, making him feel like she was going to hit him. So he put his hands up, block her from hitting him. And this continued until her grandmother stepped in, pulling her away from him. And all this occurred in Clayton County. And the recommended sentence is for count 1, 12 months to serve 15 days jail, found probated and while on probation, take a substance abuse evaluation, follow any recommended treatment, have no drugs and alcohol, and submit training and testing, and to have no contact with Mr. Thomas Green.
Okay, what's his name? Thomas Green?
Yes, ma'am.
All right, and so the recommendation, as I heard it, because you're breaking up a little bit, is 12 months to serve 15 days. Balance will be probated for a substance abuse evaluation. No alcohol or drugs during the course of the probation. She's subject to random screens for alcohol or drugs, and she's to have no contact with Thomas Green.
Yes, Your Honor.
All right, so does she still need to serve the 15 days?
Yes, she does.
Yes,
Okay,
Your Honor.
what was the reason for the motion to revoke?
She has 3 other cases. The one that was listed on there was a terroristic threat against her mother that involved her being intoxicated. Along with the other cases, usually involved her being intoxicated as well. Which is why.
All right, she's gonna do 2 AA meetings per week also.
This is the mother, Vanessa Bartel. I was summoned as well, but I wasn't in the breakout room.
You're not supposed to be. You're not a client.
Oh, okay. But can I speak on behalf of my daughter?
Sure. Let me see your video.
Oh, Lord, I'm sorry. I've been on. Hi, this is Vanessa Bartel.
Raise your right hand for me.
Yes, ma'am.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, I do.
All right. You can put your hand down. Go ahead, Ms. Bartel.
Thank you. There have been several other cases that came up with Sierra. I don't think the jail is the problem for Sierra. Sierra's not a harbor parent or a harbor child. Sierra, like you said, Judge, she needs a mental evaluation and an alcohol treatment program, not jail. She's not a bad person. And every one of those episodes, even with my ex-boyfriend, Thomas, that's my ex, when he said he wasn't even going to court to bring no charges against Sierra because he knows she had been drinking. Matter of fact, his daughter had jumped on Sierra. I didn't even call the police. There's been a family situation going on back and forth. But he told me he wasn't going to even press no charges against her over that, but he knows she was intoxicated. His daughter even jumped on Sierra, but that's another story. It's always been in the sense of Sierra with alcohol. I don't know what happened. I just feel that the jailhouse not going to help save my daughter. She have great days, she have bad days. We got to get to the psychological problem, to filling out what's making her trigger to want to drink and get angry. She has a 6-year-old son.
How old is your
She's
daughter, Ms.
30,
Barton?
she's 39, and it's been happening for the last year. I don't
Okay,
know what happened in her life, but
let me
something
ask you
has happened
this.
to trigger this.
Usually the triggers are grief or trauma. And that
Yes.
trauma can be abuse. That trauma can be somebody, beating them. That trauma can be a lot of things, but usually the triggers are trauma and grief. So only Miss Telfair will know what her issues are. But Miss Telfair, you can't keep using alcohol and then abusing other people, because the alcohol is never going to be an excuse. So while I know jail is not the treatment, at some point you're going to be punished for your behavior because you've had the opportunity to deal with your behavior in other ways. There's AA, there are programs. If you have a job, usually a lot of jobs, if you have a benefits package, have an employee assistance program. So you've had options to deal with whatever the issue is, but you choose to use alcohol. You act out in using the alcohol, and while the 15 days is not going to cure you, that might deter you from doing that, as opposed to actually going and getting some treatment. So the 2 AA meetings per week while you're on probation, that's going to be non-negotiable. You're going to have to go, and you're going to have to show proof of having gone. Are we clear?
Yes.
All right.
Your Honor, if
Yes,
may
ma'am.
I've spoken with Miss Telfair, and she was very straightforward with me about having struggles with alcohol addiction. She's let me know that she has started to go to treatment. I mentioned to her that in addition to the recommendation from the state that Your Honor would likely ask that she attend AA meetings, and she let me know that she's already started. So Your Honor, she does take responsibility. Miss Telfair also has a 6-year-old son who will be
Your old
starting
son.
kindergarten, right? And so she is asking the court that she serve her time on weekends. She does have help from the co-parent. However, just to make sure that she's not missing those first few weeks of school for him, she's asking that she serve her time on the weekend.
Is there any objection from the state?
Your Honor, they asked me about it before, and I said I wouldn't object to the jail time being weekend jail.
Okay, so the jail time can be weekends. Are you prepared to start this Friday, Ms. Telfair?
Your Honor, we're asking for her to turn herself in next Friday. She's, as I said, Your Honor, she is preparing to start kindergarten with her son.
Yeah, I can do next.
Ms. Telfair, use your time wisely. So you're wanting to turn yourself in on Friday, the 26th of July at 6 p.m. You'll be
Yeah.
released on Sunday at 6 p.m. And you'll continue until you have completed a 15 days of jail time.
Your Honor, we were asking for next Friday, which would I think be the 2nd.
No, wait, you mean okay, well, what does she want to do the second for?
Your Honor, for this week, just preparing because I believe school starts.
Start on
The school
Okay.
starts on the 1st.
So Your Honor, she was still asking. Initially, she had asked for the 9th, but I told her that at
No,
most she would give that you might give a week.
Ms. Telfair, we're not going to keep pushing this can down the road, ma'am. We're going to
No,
get these
ma'am.
days knocked out.
The second. He go to school in Fulton County. Fulton County start on the 5th.
Okay, I'll give you the 2nd, ma'am. You'll report to the Clayton County Jail on August 2nd at 6 p.m. You will serve 15 days, so you'll be sentenced to 12 months to serve 15 days to serve on weekends as directed. Your balance will be probated for you to take a substance abuse evaluation. You're to have no alcohol or drugs during the course of the 12 months. Any treatment that may be required of you from the substance abuse evaluation, you're to complete that treatment. You're to have no contact with Thomas Green. You're to attend 2 AA or NA meetings per week, and you're to show proof of having attended 2 AA or NA meetings per week. So now, Ms. Telfair, I don't know what the trigger is. I know there is a trigger. I don't know what it is, but you need to deal with the underlying reasons that you're drinking, because nobody's just drinking to drink to excess. There's something you're running from, something you're hiding from, something you're trying to dull the pain from. Get therapy for that, because otherwise you're not going to ever deal with the drinking problem, because it's always going to be there to cover up the real problem. So your son deserves to have a mom.
Yeah.
Not an alcoholic, a mom. Okay? All right. So I'm going to put you in a breakout room with Miss James. Miss James is going to get you prepared for probation. Please understand that the quickest way to get rearrested is to not appear for your probation reports. I'm going to put you in breakout room number 5. Miss James is going to be in breakout room number 5. Make sure you ask her any questions that you might have particular to your situation. You understand she can't change my order at all, but she can answer any questions that you might have. And I say again, if you miss your probation reports, that's the quickest way to get rearrested. Okay? And you will be tested, so don't assume that that first test is a freebie.
Excuse me, Judge.
Yes, ma'am.
I have 2 questions.
Yes.
Is count 2 null prost or merged?
It's no prost.
And
That's,
I need the correct spelling for the victim's name.
it's Thomas, Thomas. Is it Green, Greene, or Green?
It's without the E.
Okay, so Green, no E.
Thank you.
And
All
Your
right,
Honor,
thank
I
you.
also
Yes.
had a point of clarification. Is she getting credit for the 2 days that she served initially?
Yeah, I'll give her credit for 2 days.
Thank you.
All right, so we have a hearing for Smith. We have, I guess, whatever the announcement is for Dixon, and then McKay, I guess we'll have a hearing. He got notice, but he's absent. But the first thing I want to do is call the.
I'm here. I'm right here.
Okay, well, sir, how would I know that? Your name is not on the screen. I've been
Oh,
calling you
I'm
repeatedly.
sorry. Robert McKay. I'm right here. I'm right here. I'm sorry that I just figured out how to work it.
There you go. All right, 1 second. I'm going to call the 11 o'clock calendar. Thank you all for your patience. And Miss Hahn, did you need to be back in a breakout room with Mr. Dixon, or did you need to talk to somebody else?
Your Honor, I'll need to speak with Mr. McKay. Mr. Dixon, he told me that his iPad died as the court was addressing him last.
Oh,
so.
I saw him moving over there talking to the dog. So no, he did nothing died, and he heard me.
The iPad
completely.
did die. I can show you it died. It's still dead right now. It's only on 4%. I can show you.
Mr. Dixon.
Yeah, I still saw you, sir. All right, so Miss Hahn, I'm gonna put you in a breakout room with Mr. McKay.
McKay.
McKay, I'm sorry, Mr. McKay. I'm gonna put you in breakout room number 2. Okay, so Ms. Hahn, Mr. McKay, you're in breakout room number 2. I'm gonna go ahead and call the calendar for the next hearing, which is the 11 o'clock hearing. Keita Berry, motion to suppress. That's Lister Holt Dennis.
Yes, Your Honor. The defense moves to withdraw their motion to suppress.
All right. Brinson, Adrian Lamar Brinson, I have a motion to dismiss, but the case was closed on December 10th of 2018. Anyone here on behalf of Adrian Brinson? Case is closed. All right. Joyner, that motion was to suppress was withdrawn. And McIntosh, Milton McIntosh.
I believe Mr. Majeski also filed a motion to withdraw his motion.
All right, withdrawn. Dejanay Mitchell.
Your Honor, we'll be moving forward with that motion to suppress.
All right, Ms. Hahn, they'll be having a hearing. And Sarah Alcantar Pimentel. Alcatar Pimentel. Is there any?
They filed a motion to withdraw it.
Okay. All right, and Runolfo Rodriguez Sierra.
Good morning, Your Honor. Kendra Robinson standing in for Jerome Lee on behalf of Mr. Sierra.
Yeah, this case is closed, so I think that was a bond condition, a forfeiture.
A motion to release bond. Basically, he got deported, and I sent in the order because I believe that's how we even got to a closed case situation. But his wife wants to collect the bond money in his stead because it was a cash bond, and I mean he's in Mexico.
I got you. Is there any objection from the state?
No, Your Honor, not based on these charges. There's no objection.
All right. So we'll go ahead and sign off on that order, Ms. Robinson, and we'll get that out to you as soon as we get it signed.
Yes, ma'am. Thank you so much, Your Honor. This concludes my business before you this morning. May I be excused?
Yes, ma'am. Thank you.
Thank you. I'll see you soon. Bye-bye.
Take care. David Darrell Walker.
Yes, Your Honor. Mr. Walker is present in the courtroom. We'd ask to conference with the state before they proceed.
All right. So we'll do a conference. All right. So just hold on, Mr. Walker. We'll get you a conference with Ms. Payne and we'll get Mr. Taylor and Ms. Payne together in a conference, but let's go ahead and hear, well, I guess we can do it now since Ms. Hahn is speaking to Mr. McKay, and then she'll be back for the hearing on Smith. So as it stands, we'll have two hearings for the 11 o'clock, the 10 o'clock and the 11 Smith hearing, and Mitchell, both for Ms. Hahn. All right, so Mr. Taylor, I'm going to put you and Ms. Payne in a breakout room so you all can discuss whatever other pending cases there are. Breakout room number 3. I'll put the courtroom in breakout room number 3 also. All right, ladies and gentlemen, please be patient. We are running through these calendars as quickly as we possibly can. And now that we know what is going forward and what's not, if the state wants to release their officers on those cases not going forward, they may. Oh.
Is Mr. McKay on the Zoom call still? Mr. McKay, I don't know if you're a Zoom user. Oh.
I put him in the breakout room, but he must be having technical problems. So if he comes back and identifies himself, let me know and I'll put him back in the breakout room.
Hello, can anyone see or hear me?
We can hear you. Who are you?
Thank God someone can hear me. I don't know if I'm doing this right. My name is Keita Berry, and I was scheduled for court today as well. I've been here, but I just...
It's okay, Miss Berry.
You were talking, and I didn't want to interrupt, but as long as someone can hear me and know I'm here, I'll figure out the rest in a second.
Miss Berry, you don't have to figure out the rest. So your attorney withdrew your motion. So if you'll get in contact with them probably this afternoon or tomorrow afternoon, because they have court in the morning. But if you will get in touch with the law firm of Lister, Holt, and Dennis tomorrow, they'll explain everything to you.
And I'm sorry, what was that again? It was Holton?
Lister, Lister, Holt, Holt, and Dennis, Dennis. That's the name of the law firm. If you Google them, you're looking for the Jonesboro office.
Yes, ma'am.
Okay.
Okay, ma'am.
All right, you're free to go at this time.
And
Okay,
Your,
everyone have a wonderful day.
You too. Thank you.
Your Honor, is Mr. McKay, I mean, I don't see him in the main room, but
He was, and I changed his name, and then I guess when I sent him to Zoom, when I sent him to the breakout room, he disappeared. And I take it he had been having some issues with tech, so I don't see him right now. If he comes back in and announces his presence, I'll put y'all in a breakout room. But for now, I don't see him.
okay, Your Honor.
Want to talk to Miss Mitchell regarding her hearing, or to Miss Smith regarding his hearing, or Mr. Smith regarding his hearing?
Your Honor, yes, I would love to speak with Mr. Smith again, if that's possible.
All right,
There's-
Mr. Smith, where is he? Okay, I don't see him. Now he disappeared. Wait, maybe he stood back in a breakout room. Let me check there. Yeah, no, yeah, he's not here.
Your Honor,
Mr. Dixon's here, but Mr. Smith is not.
Okay. I will try to give Mr. Smith another call.
Okay. All right, we'll be right back.
Thank you.
Hello.
Yes, who's speaking up? Mr. Riggins? Mr. Riggins? Okay. I had your sound quality is really bad. Is Riggins a witness for someone? Because I don't have him on either calendar.
Isn't he Mr. Smith under Mr. Riggins?
No, ma'am, I had to use this phone.
Is this Mr. Riggins? Mr. Smith. All right. So, Mr. Smith, your tech is really bad. Is there a way to get to some place where you got better quality? Because you were doing so much better where you were before. Maybe he borrowed a phone, but it's not coming out clear. Mr. Smith, is still not clear. Can you have any Wi-Fi? Okay, I'm not sure how to help him, Ms. Hahn. Unless Mr. Smith.
Your Honor, I'm sorry, I stepped away briefly.
Yeah, I'm not sure how to help him unless he's like at a building that has public Wi-Fi. That might help.
Mr. Smith, are you close to the Clayton County Courthouse? Well, I'm gonna send you a chat, and maybe that's easier if you could respond to me in the chat. So it should pop up on your screen when I send you a message. But we can't, well, the judge is going to need to hear and see you throughout your hearing. So it's very important that you either appear in person or find somewhere with better service. If you can hear me now. So, Mr. Smith, I could tell that you're saying something, but I cannot understand anything.
Good afternoon, Officer Timmett. I'm just trying to see, I'm for the Ms. Keita Berry case. I'm just trying to see if I'm still needed. Notice her motion was withdrawn.
Officer, you're not my witness. I would release you, but it has to come from the state. So Ms. Hemphill, Ms. Payne, if y'all have witnesses that you want to release based on the withdrawal announcements, I'm fine with that.
I'll give him a call in just a moment, Judge.
Thank you, Investigator Pugh.
Yes, ma'am.
Excuse me.
Yes, Mr. Dixon.
I'm out. Do I still wait?
Yes, Mr. Dixon. So the judge is going to have a hearing since she decided not to accept the state's offer or our agreed upon offer. So we're going to have a hearing. So you'll just have to wait. There are one, two, I think 3 people here that are waiting for a hearing. So you will be one of those 3. So just wait patiently until the judge calls your hearing. If you have questions for me, we could go in a breakout room where we can talk on the phone.
Okay.
Okay. Actually, Your Honor, can I have a breakout room with Mr. Dixon, please?
Sure.
Thank you. Mr. Riggins, can you please, Mr. Smith, can you mute yourself, please?
Mr. Dixon is in room 2.
Thank you, Your Honor.
Say something. Hello?
Mr. Smith, just hold on until the judge returns and your attorney returns. We can hear you clearly now. Just hold on a moment until it returns.
All right, is this Mr. Smith? Mr. Smith? Okay, we're still waiting for the state and Mr. Taylor to come back to the main room, and then we can proceed. All right. Ms. Payne? Mr. Taylor, do y'all have an announcement? Y'all ready to go forward?
We're done, honestly, but I think he wanted to have a brief minute to discuss the offer with Mr. Walker.
Okay.
Hey,
Ms.
this is
Taylor,
the
okay.
Thank you. Your Honor, we do have a plea agreement. I'm just going over the details of the sentence recommendation with Mr. Walker to make sure he understands them fully. And
All right.
ready in approximately 2 to 3 minutes.
Okay, thank you.
Thank you, Your Honor.
All right, so Ms. Payne, I'm not sure if your office did it. I think they did, but if there are any officers here from any of the cases that were concluded or withdrawn that you wish to release, go ahead, or any other witnesses. But we're going forward for hearings on Dixon, on Smith from the 10 o'clock calendar, and for Mitchell on the 11 o'clock calendar. And McKay, we're still waiting for them to get out of the breakout room.
Yes, Your Honor, we have been releasing witnesses as cases have resolved.
All right, thank you.
Yeah. Oh, thing right here.
All right, there's someone under the phone, Damian Riggins. Is this Mr. Smith? Hello?
Yes, this is Mr. Smith.
All right, Mr. Smith, I'm gonna mute you because I'm hearing a lot of stuff I don't need to hear.
So, probation, 12 months probation, 12 months probation. So 6 months probation. What we can do, probably not this 24 months. But if you get everything done, you are good within the first 2 months. The last 15, 20 suspend your license. She doesn't control that. All they do is they it's not part of the judge is not saying your driver's license. This is service.
Hmm?
Thank you, Your Honor. We're ready to proceed when the state's ready to proceed.
All right, I'm ready. Okay, so this is for Walker. Who is this for?
That's correct, Your Honor. This is for Mr. David Walker.
All right, come up, Mr. Walker.
Yes, ma'am.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on 2022 CR 03493 for driving under the influence count 1, driving under the influence count 2, improper lane change count 3, striking a fixed object count 4, open container count 5, and no insurance count 6. What did your client plead to the offenses before the court, Mr. Taylor?
Your Honor, my client pleads guilty to count 1 DUI, count 2 should merge, count 3 improper lane change. My client pleads NOLO. Count 4 striking fixed object. I believe that's no prost. Open container no prost. To count 6 no insurance. My client pleads guilty.
All right. By entering a plea of guilty to counts 1 and 6, by entering a plea of NOLO to count 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis recommendation, please.
One item, Your Honor. This
Yes.
is a civil resolution that also includes case 2021 CR 08043. And if Ms. Payne will announce those charges, I don't believe they're on the calendar.
Okay, yeah. Can you tell me what those are, Ms. Payne?
Yes, Your Honor. For count 1, it is DUI less safe, less 2nd and 5. For count 2, it's open container. And for count 3, it's prohibited parking. But the state would be moving to dismiss counts 1 and count 2, and he would just be pleading to count 1. Or sorry, counts 2 and count 3, the state's moving to dismiss count, he would just be pleading to count 1.
Okay, and he's pleading guilty to count 1 on the second one?
That's correct, Your Honor.
All right. All right. So by entering these pleas, Mr. Walker, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir? All right. Factual basis and recommendation. Let's start with the oldest case, 2021 CR 08043.
Your Honor, if it would please you, the oldest case by date is actually the 2022 case. It was just accused before the 2021 case, or after the 2021 case.
I got you. Go ahead.
Okay. So for 22 CR 03493 is on or about, on or about July 11th of 2020, officers with the Clayton County Police Department did respond to an accident in Clayton County, Georgia, with possible injuries. When they arrived on scene, they observed a black Toyota Camry in the parking lot that appeared to have jumped a curb and struck a small tree. They made contact with the defendant, who was sitting in the driver's seat and yelling incoherent statements. He almost fell out of the vehicle and onto the pavement, where he lay on his stomach for several minutes. They then made contact with the 911 caller, Miss Leticia Hernandez, who stated that she observed the defendant's vehicle strike a pole in the parking lot after rolling a short distance. She stated that her and her occupants in the car tried to provide aid to the defendant. However, he was allegedly aggressive towards them and attempting to fight them. When they focused their attention on the defendant, the officer that did note that he had a strong odor of alcohol coming from his person. They attempted to assist him to his feet. However, he would become aggressive with them as well. He stated he did not have any medical conditions. He didn't know what happened or where he was at. He also stated he didn't have any injuries and confirmed that he had been drinking alcohol. When asked how much he had consumed, he replied by stating that he drinks on a regular basis. The They attempted to assist the defendant to his feet, and he continued to be aggressive and belligerent. Therefore, they placed him into custody and arrested him for DUI less safe, and no field sobriety tests were conducted because of this. As they were placing him under arrest, the defendant did make an utterance that he was an alcoholic. They then read implied consent for over 21 and asked him to submit to a blood test. He agreed, and his blood came back as a 0.272. Do you want me to do the recommendation for this or go to the next factual basis?
You can go ahead and give me the recommendation.
Right. For count 1, it is 12 months to serve, 6 days jail, credit for time served, balance probated, and while on probation, pay a $500 fine, do 80 hours of community service, take a risk reduction course, have no drugs or alcohol, and submit to random testing, and take a substance abuse evaluation following your recommended treatment. Count 2 would merge into count 1. Count 3 is a $100 fine, suspended, 12 months of probation to run consecutive to count 1. Count 4, the state is moving to dismiss. Count 5 is just a $200 fine. And count 6 is a $200 fine, suspended with 12 months of probation to run concurrent to count 1. And if you're ready, I can do the second case.
Yes.
This one is on or about October 18th of 2020. Officers were conducting a general patrol in the Clayton County area when they observed a black Toyota Camry improperly stopped in the right turning lane. They activated their emergency lights and initiated a traffic stop. And they saw that the vehicle was running and had the hazard lights were flashing. They exited the vehicle and made contact with the defendant, who was asleep behind the steering wheel. They attempted to wake him up, and it was difficult to wake him up. They flashed a flashlight in his face and knocked on the door frame and shouted at him. Eventually, he awoke and appeared disoriented. They noticed his eyes were red and glassy, and he was sweating. They did notice a smell of alcohol beverage coming from inside the Toyota, and while they were looking inside, they observed a plastic cup in the center console area with yellow liquid in it. And they explained the reason for the stop, in which he was displayed passive aggressive behavior and refused to give his driver's license. He continued to be agitated and not cooperate with them, but they did, when they stood near the driver's side door, note an odor of alcoholic beverage coming from his breath and person. They did not perform field sobrieties on the defendant based on his conduct and the aggressive behavior he was showing, but based on their findings, they denoted that he was DUI less safe and placed him under arrest for DUI less safe and read implied consent for 21, requesting a sample of his blood, and he refused. And all this occurred in Clayton County. And the recommendation for that is for count 1, it is 12 months to serve, 4 days jail, credit for time served, balance probated, and while on probation, pay a $1,000 fine, do 240 hours of community service, take a risk reduction program, do no drugs and alcohol, and follow any recommended and submit to random testing, take a substance abuse evaluation, and follow any recommended treatment, and to continue doing the Turning Point of Tampa outpatient treatment program that he is currently enrolled in, and pay the $25 publishing fee to publish his picture in the newspaper. I did not request interlock on this, no, Your Honor. For counts 2 and 3, the state's moving to dismiss, and this case would run consecutive to 2022 CR 03493.
Mr. Taylor?
Yes, just one question regarding the sentencing recommendation. Our understanding was there was going to be 280 hours total between the two cases, not basically 40 on case one.
I'm already thinking it's too light. I need to hear more about this turning point because Mr. Walker's an alcoholic. So if he's done something to address that since he picked these two charges, then we consider that. But yeah, I'm already thinking that these sentences are too light. But let's talk
Absolutely,
about
Your
what
Honor.
he's done in the interim.
Mr. Walker is participating in Turning Point of Tampa Detox and Residential Treatment Program. I've provided documentation to the state showing that he's already participated in intensive detox.
He's done detox. He's done.
Is this a counselor?
This is Ms. Walker. This is the defendant's wife, but she is also a treatment nurse for
Turning Point of Tampa.
For what?
For Turning Point of Tampa. She is the defendant's wife and is also a nurse.
So he gone to the program where his wife works?
Yeah.
In Tampa, but he's also attended programs here in Georgia and had evaluation here in Georgia as well. And Your Honor, these both of these DUIs occurred 4 years ago in 2020. And Mr. Walker's made substantial changes in his life and participated in a great deal of alcohol recovery and treatment programs, both in Georgia and ongoing in Tampa, Florida.
So they live in Florida?
That's correct, Your Honor.
So I would be expected to have all of this stuff completed in Florida?
Most of the requirements for the alcohol drug evaluation and treatment and the random testing he's been going through currently, and it's been ongoing. It's primarily the community service will be the one item of the sentence that probation would monitor that would need to occur in Florida.
Mr. Walker?
Yes, ma'am.
Tell me in the interim where I'm concerned about you ever getting back on the road again. You were 0.272. You was pickling yourself. It takes time to get up to a 0.272. You just don't do that and then walk away. You got to work up to that kind of blood alcohol level and still be coherent and not hospitalized. So tell me what you've been doing in the interim to get your life back on track.
Excuse me. Me personally, I had went and did the detox as my wife had explained. Then I did residential. Then I did partial hospitalization. Then I did intensive outpatient, and now I'm downgraded to outpatient. That process started from March 5th and it's ongoing. Every morning, Monday through Thursday, I have a home group AA meeting that I attend at 7 a.m. Tuesdays and Thursdays is when I attend my outpatient classes from 9 to 12. I work on Friday, Saturday. That's my work schedule, Friday, Saturday, Sunday. I do about 13 hours a day. That's the only reason I don't attend a meeting on those 3 days.
Okay, what you do for a job?
Forklift work, U.S. Foods.
You from New York or Philly?
I'm from Brooklyn, New York.
That's where I was born. I heard it.
Yes, ma'am.
You have children, Mr. Walker?
Yes, ma'am. I have 4 children, 3 daughters and a son. Youngest child is 14.
Ooh, I got one of those. Yeah. You've done some substantial work. I don't have that you have had anything else, but you recognize my concern, right?
I most definitely do, ma'am. Yes.
But
Yeah,
you see, yes.
If you would like to know, we did run an updated criminal history on him, and for both Georgia and national, he does not have any new charges since 2020.
Okay, that works. You have an amazing support system, Mr. Walker, because there are not too many people who have a spouse or a loved one who's trained in addiction recovery. I happen to have one. My husband used to run a sober house. So I've heard stories of, how difficult it is to kind of shepherd people through that process. And then to have it be somebody you love who has to assist you, I understand that. And so my a lot of respect for Mrs. Walker and how she's assisting you through this process to try and get her family back on track. Because of what I heard, my concerns have been somewhat allayed, that you are participating in a treatment program. It's the type of treatment program we wish we could offer to other people, and that you are in a program that has progressive steps, and you have altered even your work schedule so that you can prioritize your recovery. Because at the point where you stop prioritizing your recovery, then that's the point where things are going to go off the rails. And this is what I say. A lot of people either are in denial that they have an alcohol problem, or they believe that it is something they can handle themselves. It's not, necessary to really devote time and energy to it. Just, I can stop anytime I want to, as we've heard. But I believe that anytime you have a medical issue like hypertension, diabetes, those things where if you take your eye off the ball, if you stop using your medication, if you stop doing the lifestyle changes that you need, you will suffer severe physical consequences, and including death. I think alcoholism is the same way. The severe physical consequences are that at any given time, if you get behind the wheel impaired, you could kill yourself, injure yourself, or injure or kill someone else. And so, and the other things are, if you are in a continuous state of alcoholism, you lose connections with your family. You lose the respect of your community because they feel like you're not trying. Even as hard as it is, you lose those connections. And so what I would ask of you is to remember that you got at least 5 reasons to want to continue to maintain your sobriety. And I always say this too, that sometimes alcoholism is not the disease itself, but it is a response to some kind of issue, either a trauma issue or a grief issue that we haven't dealt with. And so if you find that through your recovery, there's an underlying issue that prompts you to use alcohol to numb that issue, then you need to dig it out, do the work, and start dealing with that in order to be healthy. Okay?
Yes, ma'am.
All right, so I'm going to accept your plea on case 2022 CR. I'm doing that one first because that was the oldest in time, and I guess that's the one we did. 2022 CR 03493. Accept your plea of guilty to driving under the influence. Count 2 will merge. Count 3 will is a NOLO plea. Count 4, null pros. Count 5, I guess NOLO plea, and count 6, guilty. On count 1, 12 months to serve, 6 days credit for time served. Balance will be probated for you to pay a fine in the amount of $500. The fine is going to be pretty hefty because the surcharges on a DUI fine are pretty heavy. And so I can't even quote you. Generally, it'll be $737, but it's going to be over $1,000, I think. And I don't know that particular amount. It's going to be 80 hours of community service, risk reduction course, no alcohol or illicit drugs during the course of your probation, and you're subject to random screens for alcohol and drugs. I will accept your drug screens, your substance abuse evaluation and treatment that you're undergoing as part of the Turning Point outpatient program, as long as you keep those reports, present those reports to your probation officer. Count 3 will run concurrent with count 1. It's a $100 fine suspended. Count 5 is a $200 fine, which will run concurrent with count 1. That'll be $298 with the surcharges. Count 6 is a $200 fine, which is suspended. That also will run concurrent with count 1. Now, this case will, the next case, 2021 CR 08043, will run consecutive to 2022 CR 03493. On that case, count 1 is guilty, 12 months to serve 4 days, credit for time served. The balance will be probated for a $1,000 fine, plus surcharges, and 200 hours of community service. A risk reduction course, no alcohol or illicit drugs during the course of your probation. You're to continue the treatment from Turning Point outpatient outpatient service, and you're to continue the AA meetings that you have started under the program and show proof of having attended those meetings. That, like I said, count 1 of that case will run consecutive to the previous case. Counts 2 and 3 will be no pros. I'll allow Mr. Walker, because he's in treatment in Florida, to serve by phone and mail. Mr. Walker, what that means is your program is going to have to mail those forms in on your behalf. You'll get the paperwork from probation. Just be timely in your reporting. The quickest way to mess up, to destroy all that you've worked for, is to fail to report, and to continue to take those classes and attend those meetings that will keep you on the path. And Mr. Walker, what my hope for you is that you get to the point where you're able to help somebody else in recovery. When you get to the point where you can be a sponsor, where you can help someone else, where you can share your journey with them so that you can help someone else get their life back on track, that to me is success. Okay. All right. So I'm going to ask you, when you leave the courtroom, you'll go out to the right. In that first courtroom to our right, 305, if you go through the double doors, Ms. James should be in there and able to sign you up. If she's working with somebody, she'll just ask you to sit in the hallway, okay? Just remember that if you have any issues, please contact your probation officer here first and let them know that you're having any difficulty with any part of any of the sentence that the court has imposed, okay? All right, Mrs. Walker, thank you for your assistance in this matter, and being steadfast in helping Mr. Walker to stay on the path.
Yes, ma'am. Thank you. Thank you.
All right. All right.
One additional item, just ask
Yes, sir.
a recall for the bench warrant and bond forfeiture.
All right, we'll recall the bench warrant, bond forfeiture, and I'll sign that as soon as I get it.
Thank you, Your Honor.
All right,
He
Mr.
had a
Taylor.
bench warrant bond forfeiture in both cases.
Yeah, I guess whatever we had them in. The pleas themselves should take care of those, but if they don't, I do like to
Hello?
issue recalls just in case.
Thank
All
you.
right, Mr. Taylor, did you have any additional hearings or pleas?
No, Your Honor, we withdrew our other motion.
Okay, I was just checking. Ms. Hahn?
Your Honor, Mr. McKay was having some tough technical difficulties, but in the interest of time, I think we're ready to move forward on whichever hearing needs to go first.
All right, let's start with Smith, because we've had some issues with his tech. So, Mr. Smith? Where is he anyway? Why didn't he just come to court?
Your Honor, so for Mr. Smith and Mr. McKay, I had no good phone number for either of them and hadn't spoken to them. I did speak with Ms. Val though, and she had instructed me that the motions to revoke should come into court, and I would have, had I been able to would have instructed them as to that had I been able to speak to them. So today is my first time speaking.
But they got the notice because they're here.
Yes, Your Honor. I guess that their notice, or somebody told them to appear on Zoom. So I'm not sure why they didn't appear in person.
All right, y'all get set up for the hearing and I'll be right back.
Thank you.
How you doing? I'm sorry. I'm Officer Sanders. I'm here for the Dixon case. Do I still need to be here?
Yes, sir. We are going to have that hearing sometime after we have Mr. Smith's hearing.
Okay, no problem. Thank you.
Mr. Smith, um, um, actually, never mind.
Good afternoon, Your Honor. There is no more people in the courtroom, so is the courtroom clear to leave the meeting?
Deputy, if everyone is done, all the defendants are not in the courtroom, everyone is done in the courtroom.
Yeah, there's nobody else in here.
Okay, you can shut it down.
Okay, thank you.
All right, we're ready on Smith.
Mr. Smith. You need to turn your camera on. Do you understand we're about to start the hearing? But you can stay.
Mr. Smith? Hello? Matan?
Yes, Your Honor. As you can see, he appears to be on the Zoom call still, but he's not.
Okay, tell Mr. Smith he needs to come to the courthouse.
Yes, Your Honor.
Yeah, we're not doing this. Because his hearing notice said come to the courthouse. So I don't even know why I'm entertaining this. All right. Oh, next, Mitchell.
Yes, Your Honor.
All right, we're ready on a hearing on Mitchell.
Yes, Your Honor, we're ready on Mitchell.
Just to be clear, we're going to do the motion to suppress from the 11 a.m. calendar before we address the rest of the hearings on the 10 a.m. calendar.
Well, I can't get clarity. So McKay, what are we doing on McKay?
Your Honor, that was a hearing, should move forward. And then same with Dixon, unless Your Honor is willing to reconsider.
Okay, and which one is a motion to suppress?
Your Honor, Ms. Mitchell is a motion to suppress, and then the other two, McKay and Dixon, and Smith, are motions to revoke bond.
All right, so we can do what we can do. Dixon first.
Hold up. I'm right here. Why are you doing?
Mr. McKay. Mr.
I don't
McKay.
understand.
Well,
Because I keep going in and out. I got you though.
Mr.
Listen,
McKay, please do not
cut
say
you going
anything
in.
else. Just press mute, please. Thank you.
Mr. McKay, my hearing notice said you were to come to court for the motion to revoke bond. You're sitting up in your bed. So I'm already giving you a little bit of grace because I haven't sent Clayton County Uber to come pick you up. And I'm dealing with you and all your technical issues, which you wouldn't have if you were in the courtroom. So what I'm gonna need you to do is stop yelling out declaratory statements and listen to what's going on so you have a clear understanding. Where you are here because you picked up an additional charge after your first charge, thus allegedly violating your bond conditions. There may be other reasons that you may have violated your bond conditions. And so that's why the motion to revoke was ordered. So we'll sit here, we're going to have a hearing. You're going to let your attorney talk and we're going to go get through this hearing, okay? Clear?
Yes.
All right,
Yes,
thank you
ma'am.
so much. Okay, so now, where's Mr. Dixon?
Your Honor, he's on the Zoom
Up
call.
here.
I don't see him.
Mr. Dixon, if you
I'm
could
here.
please turn your camera on.
I gotta allow it because I had to change devices because my other one died.
You who to what?
I said I had to change devices because my other one had died. So I'm trying to work it
You
right
don't
now.
have a cord that you can just hook it up?
I did, but it still was dying.
All right, so lower the camera so I can see your full face. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. You can put your hand down. Mr. Dixon, you're before the court on State of Georgia versus Ray. Hold on a second. Raekwon Lamar Monte Dixon on case 2024 CR 0702178. You're represented by the law firm of Lister, Holt, and Dennis. Ms. Hahn is with you on the video call. This is a motion to revoke bond. The state is represented by Assistant Solicitor General Payne. Ms. Payne and Ms. Hahn, are we ready to go forward on this case?
Yes, Your Honor.
All right, Ms. Payne.
Yes, Your Honor, the state would call Officer Sanders to the stand.
All right, Officer Sanders, may I see you, please? Raise your right hand for me.
Yes,
You
ma'am.
solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am, I do.
All right, you can put your hand down. You're before the court for the hearing on State of Georgia versus Dixon, motion to revoke, and the state has called you as a witness. Ms. Payne, your witness.
Yes, Your Honor. And I meant to say before I ask Officer Sanders the first question, I was going to ask the court to take judicial notice of the fact that Mr. Dixon was out on bond from April 5th of 2023 with the bond conditions to stay away from Miss Nia Jones, the bond condition to stay away from 1018 Gardenwood Drive, College Park, Georgia, and to not violate any other laws of the state.
Any objection to the court taking judicial notice?
No objection, Your Honor.
All right, court will do so.
Officer Sanders, can you state your name, please?
I'm Officer Sanders from the Clayton County Police Department.
How long have you worked there, sir?
Almost 3 years now.
Did you work there back on September 3rd of 2023?
Yes, ma'am.
Were you on duty that day?
Yes, I was.
Did you receive a call from dispatch that day?
Yes, I received a call from dispatch to go to I believe her name is Miss Nayaz. I'm sorry, I don't have the paper in front of me. Um, for a domestic dispute.
Did you respond to 1018 Gardenwood Drive?
Yes, ma'am.
Is that in Clayton County, sir?
That is.
Okay. And you stated you made contact with Miss Naya Jones?
Yes, ma'am, I did.
And what did she tell you, sir?
Miss Nia Jones stated that Mr. Dixon was at her apartment and they got into a verbal dispute that turned physical. She showed me that she had minor lacerations to her neck and chest area. She showed me that there was damage to property in her residence. It was a table and chair set that was destroyed. She also said that her iPhone was taken as well as her firearm.
Okay. And did you observe damage to a TV and a living room table in the entertainment center?
Yes, ma'am, I did.
Did you estimate approximately how much damage that was?
It was over $500 worth of damage. What she was able to tell me was that the iPhone itself was about $300, and I don't recall her giving me an amount for the entertainment system, but the TV was well over $300 as well.
And the TV was well over $300 or $500. What'd you say?
It was over $300.
And were you able to make contact with the defendant on that day?
No, ma'am, he wasn't there at the residence.
And at the end of your investigation, did you decide to take out arrest warrants against the defendant?
Yes.
And what warrants did you take out?
I took out warrants for battery and criminal damage to property due to the total estimate of damages, as well as theft by taking.
Okay. And
let me ask this question. So, sir, were you aware that he had previously been arrested?
No, I wasn't aware. At the time of the incident, I wasn't aware.
Were you able to ascertain that?
Sometimes you can see it in our system when we run people's names, but when I received his information from the victim, nothing appeared that he was already arrested for the previous incident. But the victim did specify that this has been an ongoing event with them too, as far as domestic violence.
Did at any time you determine that there was a bond condition in place that prevented him from going to that location or having contact with her?
No, I wasn't aware of that.
Is there a way to be aware of that?
We would have to call the Clayton County Sheriff's Office to verify if there was a bond condition, but normally for us to know, usually victims will tell us that the person is not allowed to be at the residence.
So if someone tells you that, do you take the next step to verify whether there's a bond condition?
Yes, normally we would ask if they have paperwork, or we would just ask what the charges were. So when I called the jail with his information, they could just tell me what the bond conditions are.
All right. And at that point, if it is found that they had bond conditions, as in this case, to stay away from the person of Ms. Jones and to stay away from the location, would you then take any further action as to take out a warrant for aggravated stalking or a warrant for violation of a bond condition?
Yes, normally in the past, I've taken out warrants for aggravated stalking due to the incident, as well as contacting probation officers if they are on some type of probation.
But in this case, you didn't do that because you didn't see the information?
Yes, I didn't have that information on hand at the time of the incident.
Okay. All right. Anything else, Ms. Payne?
Just one more question, Officer Sanders. When speaking with Ms. Jones, did she indicate whether the defendant and her were residing at the same address?
She did. I mean, in this instance, she didn't use the verbiage of he lives here, but it was implied that he stayed at the residence, which is the reason why I didn't feel comfortable making my charges family violence. So I just added in my report that he stayed at the residence based on what the victim told me.
Thank you, sir. No further questions.
Ms. Hahn?
Thank you, Your Honor. Good afternoon, Officer Sanders. You never spoke with my client, correct?
No,
You never saw him at the incident location, correct?
correct,
You never saw anything that happened as far as this incident, correct?
correct,
Okay. So you're not sure that my client was even at the scene, correct?
correct. This was testimonial evidence that was given to me when I spoke to the victim.
Okay. And you're not sure that my client did any of the things that Miss Jones had mentioned that he did, correct?
Correct. I had no substantiated evidence to prove that your client committed those acts.
Okay. And how did you assess the value of the television?
Based on the inch of the television, I just normally go online and see what the cheapest is and price it that way whenever a victim can't tell me. But the estimated value of the cell phone was given to me by her.
Okay. And did you verify that as well online?
No, because the phone that she had was an older model, so
Okay.
it was based on whatever she paid for it at the time.
Understood. Okay. And then I just wanted to clarify just one of the judge's questions. She never told you at any point that my client was living there. It was just implied. Is your testimony correct?
Yes, it was implied based on how she addressed him, and she made statements to say that he stays here, but she wouldn't validate whether he lived or reside at the residence.
Okay. All right. No further questions, Your Honor. Thank you, officer.
All right, anything else, Ms. Payne?
Yes, Your Honor. Officer Sanders, would you take out warrants for the defendant if you didn't have evidence to believe that he in fact did strike her with an open hand, causing a neck laceration and damage her TV and living room table?
Yes, I did.
Okay, well, yes, you would take out warrants if you didn't have
I'm
evidence?
sorry, can you?
No, you wouldn't.
Yes, I would. Based on the amount of damage and what was stated to me by the witness, that's what made me go forward with taking out my warrants. And as I explained it to the judge that granted me the warrants, that I didn't have him on the scene. Normally I try to make contact with the suspect via phone call, but that's not always successful. My victim was very adamant that he was the only one at the residence with her.
So based on how Ms. Jones was communicating with you and how adamant she was being, you had enough evidence to take out warrants for battery and criminal trespass in the second degree and theft by taking, correct?
Yes, I used the testimonial evidence to go forth with the warrants.
Thank you, sir. No further questions.
Anything else, Ms. Hines?
No, Your Honor.
All right, does the state have, is the state done with this witness?
Yes, Your Honor.
All right, may this witness be excused?
Yes, Your Honor.
All right, does the state have another witness to present at this time?
Yes, Your Honor. The state would call Officer Aguilar to the stand.
All right, Officer Aguilar, unmute for me. Mr.
Good afternoon.
Dixon, I can't see your face. I keep seeing a ceiling. All right.
Because I have the phone close to me because the sound is not loud, so I'm trying to listen.
Okay. All right. Officer Aguilar.
Yes, ma'am.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. Officer Aguilar, you're before the court for the motion to revoke State of Georgia versus Dixon. Ms. Payne, you're a witness.
Yes, Your Honor. Officer Aguilar, can you state your name, please?
My name is Jennifer Aguilar.
And where do you work, ma'am?
I work with Clayton County Police Department.
Apologize. And how long have you worked there, ma'am?
I've worked there about 2 years now.
Did you work there back on February 15th of this year?
Yes, ma'am.
Were you on duty that day, ma'am?
Yes, ma'am.
And did you receive a call from dispatch that day?
I did.
And where did you respond to, ma'am?
Gardenwood Apartments.
Is that in Clayton County?
That is in Clayton County.
And who did you make contact with when you responded there?
I made contact with Nia Jones, the victim.
And what did she tell you?
She stated that she had engaged in a verbal altercation with her boyfriend, Mr. Dixon, over Valentine's Day because he decided to spend it with his friends instead of her. They started arguing and he slammed the door on her hand. So you have visible injuries to a couple of her fingers. The pictures have been attached to the report. When I got on scene, he was not on scene, but we've responded out to that residence a couple times and he does the same thing. He runs out the back to the woods. Yeah, and the whole house was in disarray from the altercation.
And you stated that you saw visible injuries on her fingers. What visible injury did you see, ma'am? Do you remember?
Yes. So there was a bleeding cut, or it's like you could see it was slammed. Like her hand was slammed in the door, so there was cuts to like 3 fingers, and there was a previous call also placed at dispatch, but they only asked for EMS, where she said her hand was smashed, but she neglected to let him know that it was over domestic issues. Then there was a second call because the altercation continued. That's when she called for the actual reason why or how she acquired her injury.
So, it's your testimony today that the injury that you observed was consistent with her hand being slammed into the door?
Yes, ma'am.
Okay. And did she let you know who slammed her hand into the door?
Yes, ma'am.
And who'd she say did that?
She said it was her boyfriend, Raekwon Dixon.
Okay. And you said he wasn't on scene when you arrived there. Did you attempt to locate him at all?
I did. Yeah, we did. We usually try to call him on the phone. He was not answering. We stayed at the location. We went through the woods looking for him. He wasn't there. So I requested warrants for him.
And what warrants did you request?
Battery.
And did you request it for just battery or battery family violence?
Battery family violence.
And why did you request the family violence element to it?
Miss Jones said that he was staying there. He had been kicked out of his mom's house. So whenever they get into it, he goes to his mom's house, but he mainly stays there. He also had belongings in the house and stuff with his name on it. So that gave me the impression or implied impression that he lived there. His kids also stay there as well. So they have belongings there as well.
All right. And did she also tell you that she no longer wanted the defendant at her residence anymore?
No, she did not state that.
Did she tell you that this was not the first time that she has called law enforcement on him?
That's affirmative. She did state domestic history.
Okay. And actually, thank you, ma'am. No further questions.
All right, cross-examination.
Yes, Your Honor. Officer Aguilar, you mentioned my client wasn't at the incident location. You don't know that he was ever there, do you?
Yes, they have security cameras in the house. So the camera security footage has like a view of the living room. So we see that he's at the location, and at the moment of the altercation, they turn the camera. So
Okay.
Yeah.
You weren't present at the time of the altercation, correct? Of the alleged altercation?
No, ma'am.
So you're not aware that my client could have been acting in self-defense if there were even an altercation?
No, ma'am.
Okay. And had you ever made contact with my client before?
Not physically. No, ma'am.
When you say not physically, what does that mean, Officer Aguilar?
When we respond out to the resident and he leaves the scene, he'll talk through us through the door camera.
So you've been there before?
Yes, a couple times.
Tell me how many times you think you responded to incidents at this location?
Probably like 3 times that I can remember.
Okay, was that with Officer Sanders or is that on your own? Or with another
That's
officer?
That's on my own with other officers as well. So I'm morning, Sanders is the evening watch.
Okay.
And Officer Aguilar, so you said you had responded before, but you've never personally seen my client. Do you know what he looks like?
I've seen him on camera, like I said. I know he's got like longish dreads. I know he's like a skinnier build from afar, or just, we check through NCIC GCI software, so I look at his image, but he always does the same thing. He leaves before we get there.
Okay, so you're not sure if the person that's been talking to you through the door is even my client, correct? You can't say for certain.
I can't say for certain, but he responds to my questions as if he were the person in question.
Okay. 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 And so you took out a warrant for my client's arrest without ever hearing his side of the story, correct?
I remember I took out the warrant, but I felt confident in my warrant because when I was talking through the camera, it was him responding. I had his children. His children. I'm sorry, I don't want to confuse it with the other times I've been there. I know I felt confident taking out the warrant. I wouldn't have taken out the warrant if I hadn't felt confident that I was talking to him. But I don't think maybe that occasion I talked to him.
Okay. All right, no further questions, Your Honor.
Any redirect off Solicitor Payne?
No, Your Honor.
All right. Anything else for Officer Aguilar?
No, Your Honor, she can be excused.
All right, Officer Aguilar, you can be excused unless you have something else pending on the calendar. All right. Does the state have any additional witnesses to present?
The state would call Miss Nia Jones.
All right. Miss Jones? May I see your face, please?
Yes, ma'am.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, Ms. Jones, you're before the court on State of Georgia versus Dixon. Ms. Payne, your witness.
Thank you, Your Honor. Miss Jones, can you state your name, please?
Najee Jones.
Oh, I apologize for mispronouncing it then.
Thank you.
How do you spell that, ma'am?
NYJAYA.
Okay. And Miss Jones, are you the named victim in Raekwon Dixon's case back from April 4th of 2023?
Yes.
Okay. Did you also have reason to call 911 on September 3rd of 2023 and February 15th of this year?
Every time I've called, I've had reason. Yes, ma'am.
Okay. And specifically, let's start with September 3rd, 2023, just because that goes chronologically. What was your reason to call 911 that day?
The first incident, it was a verbal altercation that turned a little physical. There was a lot of pushing from Mr. Dixon.
Ma'am,
thing-
not trying to truly cut you off. I'm not actually asking about the first incident back from April. I'm fast forwarding to September 3rd.
There's been so many.
When Officer Sanders responded to the scene. And do you remember, did Mr. Dixon ever break your TV and your living room table?
Yes.
Okay. To your knowledge, did that happen on September 3rd, 2023?
Yes.
Recollection. All right. And on that day, did he also hit you, causing a laceration to your neck?
Your Honor, objection is leading.
Sorry?
Open-ended questions, Payne.
Yes, Your Honor. Ms. Jones, on that day, did Mr. Dixon hit you?
It wasn't a, yes, ma'am.
Okay. Did you get an injury from him hitting you?
Yes.
What injury did you get, ma'am?
I have scars on my neck. It wasn't a hit. It was like a scratch from the altercations. It wasn't a direct strike, if that makes sense.
It does, ma'am. And then after he struck you and scratched you, did anything else happen that day?
It was all one altercation.
Okay, so when you say it was one altercation, what do you mean? What happened during that whole altercation?
It was a verbal altercation that turned physical. I can't honestly tell you exactly how everything went down. I have too many situations to try to remember the exact one.
Okay. Do you remember roundabout with that incident? Not necessarily specifically, but roundabout what turned the altercation physical?
I can't say.
Okay. And when the altercation turned physical, besides injury, did you also get property damage?
Yes.
And what property was damaged on that day?
It was my TV, my entertainment system, my living room table set. Yeah, I believe that's all that was.
Okay. And did he take anything of yours that day?
Yes, my iPhone.
Right. And approximately how much damage to your knowledge was done that day, financially speaking? Like approximately how much damage was it?
I had to say about $600 worth of damage.
Yeah. And do you know approximately how much your iPhone was worth?
I'm honestly not sure. It was an older iPhone, I believe like an iPhone 11, so probably around $200 or $300.
Okay. And at that specific time, to your knowledge, did Mr. Dixon have a bond condition to stay away from you and from 1018 Gardenwood Drive?
Not that I know of.
You weren't aware of the bond condition?
No.
Okay. And when you called law enforcement that day, did you relay to them everything that happened?
I'm sorry?
When you called law enforcement on September 3rd, 2023, did you relay to them everything you just told us?
Yes.
Okay. And to your knowledge, was Mr. Dixon on scene at that time?
No, he wasn't.
What caused him to leave?
The fact that I was calling the police.
Okay. And to your knowledge, did the law enforcement officer take out warrants for him for that altercation?
I believe he did, yes.
Okay. And then moving to February 15th, 2024, did you have a reason to call 911 that day?
I believe that is when my hand was smashed in the door.
And how was your hand smashed in the door?
I was trying to leave out of my room, and Mr. Dixon was holding the other side of the door. With me trying to get out, I put my hand in the way of the door, and it ended up getting stuck in the door while he was trying to close it from the other side.
So, if I understand correctly, what you just said is that you were trying to leave your room and Mr. Dixon was trying to prevent you from leaving your room? Is that correct? And in the altercation of him trying to prevent you from leaving your room, did you testify to that your hand was in the way and he slammed the door on your hand?
Yes, my hand got slammed in the door.
Okay. And did you get a deep cut on your fingers for that?
Yes, it was bad. I called EMS before I even called the police that day, and they came and checked it out and wrapped it up for me.
Did you end up ever going to the hospital to get stitches or anything for it?
No.
All right. And did the defendant reside with you at that time?
No.
Was he coming back and forth to the house?
Yes.
Okay. Has he ever lived with you at that place?
No.
And do you see the person on the Zoom platform today that slammed their hand into the door, causing you to get a gash on your finger? And
Mr. Dixon, I need to see your face.
And then back on September 3rd, took your phone and broke your entertainment center and your TV and caused a scratch on your neck. Do you see that person on the Zoom platform today?
Yes.
Right. Can you identify him?
Raekwon Dixon.
Can you identify him by something that he's wearing or the background behind him?
He has locks. There's a brick background.
Okay. Thank you. No further questions.
Ms. Hahn?
Thank you, Your Honor. Ms. Jones, you often take care of my client's children, is that correct?
Yes.
Okay. And you have a good relationship with them?
Yes.
Okay. You have a good relationship with their mother, is that correct?
Yes.
Okay. You said that your hand got slammed, and it caused you to call EMS. Is there a reason that was the first call that you made?
Not necessarily. I didn't want to call at all.
And how long between the time that you called EMS was it that you called the police?
Maybe a couple hours.
Couple hours, okay. Okay. All right. No further questions, Your Honor.
Ms. Jones, I have questions. So,
Yes,
Ms.
ma'am.
Jones, how old are you?
I'm 22 years old.
How old is Mr. Dixon?
He is 25.
Okay. And how long have y'all known each other?
For about 3 years now.
Okay. And how does Mr. Dixon, you say he doesn't live there, but he keeps coming back and forth. How does he keep getting into your house?
Various ways. I have let him in before. If somebody else is there, then they'll let him in.
You live alone or you live with someone else?
I live by myself.
Okay. Do you have any children?
No, ma'am.
Okay, so the only children that would have been in the home would be the children that he has?
Um, no. Well, at the time, yes, but no, I
Okay.
have more than just his children that go to my house.
Okay. All right. You keep kids or you just keep his as a favor to him?
No, I was keeping his as a favorite to him, but I have my siblings and other kids like that that go over to my house.
Okay. All right. All right. Did the state have any other questions for Ms. Jones?
No, Your Honor.
All right. Did the defense have additional witnesses to present in this case?
No, Your Honor.
All right, I'll entertain argument.
The state would just waive its right to opening and reserve the right to close.
All right, Ms. Hahn?
Your Honor, we're asking that the bond not be revoked in this case. The state's first two witnesses, the officers never saw my client at the location of the incident. They don't know what happened on that day. They've only taken the testimony of testimonial evidence from the alleged victim. Let's see. And then also in the state's motion, they have they're requesting to violate or revoke, excuse me, the defendant's bond based on a battery family violence charge. And there is no battery family violence in this case, considering the fact that the alleged victim and my client have never lived together. They don't have children together. So it wouldn't be a battery family violence if there were even enough evidence to show that there were an altercation that took place on that day.
Was your client arrested for said altercation, Ms. Hahn?
Your Honor, he was.
Okay, and generally, if they arrest, it's usually not until a plea or trial that the case is examined to see whether the charge needs to be changed to just a plain battery or plain battery family violence. Is that correct?
Yes, Your Honor.
And so the basis of the bond in this case would be based on what he was arrested for and the fact that he was not to violate any of the terms and conditions of the bond. Is that correct?
That is correct, Your Honor.
So the substance of the arrest would come for later when it's a plea or a trial, not with respect to what the requirements are for bond. Is that correct?
Yes, Your Honor.
All right, go ahead.
Your Honor, while that is true, our contention is that because we don't believe there's sufficient evidence for the arrest in the first place. The fact that he was not present shows that he wasn't a danger to the alleged victim in the case. I don't believe the state has met their burden of proving that in any way. There's been no evidence to show that he was even at the scene or that he has had contact with Ms. Jones. So, Your Honor, we're asking that his bond not be revoked.
All right, I'll hear from the state.
Yes, Your Honor, the state does feel that we have met our burden to show that Mr. Dixon's bond should be revoked.
Just 1 second, I'll be right back.
Is Mr. Smith still on?
I thought the judge told him to come to the courthouse.
Yeah, I didn't know if he got that message or not. So that's what I was looking. I don't see him, but
Hey, how you doing, Ms. Hahn? This is Officer Shelby on that case with Mr. DeVarsity Smith. Are they sure he's going to show up for court? Because this is my off day, and I've been here since 10. So
yeah, I mean he was here on the Zoom call. So I guess I'm gonna keep trying to call him to make sure that he appears in the courtroom. So
yeah, because I know his residence is in Ellenwood. I think he lives in Ellen, but his mom lives in Decatur. So I'm trying to figure out if he's in Decatur or not.
oh, like as far as like distance wise and getting to Clayton County.
Yes, ma'am.
I will keep trying him.
All right, thank you.
Also, Shelby, I'm pretty sure the judge is going to want to go forward with the motion to revoke bond, even if he doesn't physically show up in the court. So
Understand.
continued patience would be very much appreciated. I apologize.
I'm clear.
All right, Ms. Payne, thank you. Go ahead.
Yes, Your Honor. The state does feel that we've met our burden to prove that Mr. Dixon's bond should be revoked and that on April 5th of 2023, he was let out on bond for a case against Miss Nia Jones that was a simple battery, family violence, and was told not to stay away from Miss Nia Jones, to not return to 1018 Gardenwood Drive, and to not violate any further laws of the state. And while on bond, you heard today testimony from two officers and Miss Jones that he committed two more offenses, but two more separate cases against Miss Nia Jones. And one case from September 3rd of last year, the officer testified that he saw damage to property that would be criminal damage, property in the second degree, because it amounted to over $500. You heard Ms. Jones testify to the fact that Mr. Dixon is actually one who broke her property, caused a laceration to her neck, and stole her cell phone. You also heard her testify to that just this year, in February of this year, he committed another offense against her when he slammed her hand into the door and got a gash on her finger that she actually received treatment from EMS on. And that according to OCGA 1761, the purpose of being out on bond is the court is supposed to find that the defendant poses no significant risk of fleeing from the jurisdiction or failing to appear in court when required. And even today, he was told to appear in person, and we're here on Zoom where he hasn't appeared for court in person as required. The next thing is that he poses no significant threat or danger to any person, to the community, or to any property in the community. And clearly he's posing a threat to Miss Jones as he keeps going back over there, violating the conditions of bond that the court has set, not even disregarding what the court is actually ordering him to do. Could also pose a risk of intimidating her, which is another element of the bail. So the state would ask that you do find that he has violated the conditions of his bond and that you do revoke him until his trial can be heard on this case.
All right. All right. Ms. Hahn has argued that there was no evidence that Mr. Dixon was in fact the perpetrator in these offenses, but Ms. Jones has testified that not once, not twice, but 3 separate occasions, Mr. Jones has come to her house where she says does not live, but has come and it's ended up with a situation where there was violence, where she suffered injury, where her property has been damaged, property that is solely hers because she says that it is her home. They don't share any kids together, and I did not hear from the testimony that they were living together. However, the fact that he was arrested on a battery, family violence, as opposed to a battery, that's something that gets cleared up on the plea or on the trial. But the arrest, the bond that was done on the arrest, the bond condition itself requires that he not have any contact with her, and that he stay away from her location. Well, he has violated, per the testimony presented by both officers and by Ms. Jones, he has violated both of those provisions of the bond conditions. In addition to that, he's violated the provision of the bond condition that says that he's not to have any additional criminal charges once you are out on bond. Bond is for the purpose of assisting your counsel with the defense of your case. It is not to run rampant and go back to the same location that you were prohibited from going to in the first place and having contact with the person who's the alleged victim in the first place. Mr. Dixon, I don't believe that the plea that was discussed would have been sufficient to deter you in any way. You talk about you got a dog, you have kids, but you're not in any way showing the type of personality or temperament that would suggest that you are somebody who needs to be out on bond. You have already violated 3 of the conditions of your bond. And so at this time, the court is going to issue an arrest warrant. You're to be taken into custody as soon as possible. Mr. Dixon, you can make an arrangement with your attorney to turn yourself in. That would probably be best because I don't control what happens on the street. But there will be a warrant for your arrest. You will be held in custody until such time as your case is resolved, your cases are resolved, or you have trial of those cases. Your bond is revoked.
Your Honor.
On both cases.
Your Honor, I just wanted to ask if the court would be willing at some point, not today, to hear, I guess, to have a plea in the case.
No, ma'am, not today. No, I don't see myself being willing. Not anytime soon. No. Because plea to me means Mr. Dixon's going to get back out. Right now, Mr. Dixon is a clear and present danger to the community. And in my responsibility to protect the community, Mr. Dixon, I just don't see a plea being something that would satisfy that for me.
Understand, Your Honor. We would ask then that he be placed on the next available trial calendar.
If he's an inmate, his case goes up to the top. But other than that, he gets no preference. Mr. Dixon, like I said, you might want to talk with your attorney and turn yourself in. Otherwise, there'll be a warrant for your arrest.
And Mr. Dixon, I obviously will not be able to answer the phone as soon as this hearing is over because I have 2 more hearings. So I'll give you a call after court is over today.
All right. Thank you. Yes.
I just, huh?
I'm sorry.
Say that again, please.
I'm wondering, did you have a question or you aware that I've just revoked your bond?
Yes. So my offer to do the 90 days is gone.
Yes, sir.
All right.
Your Honor, may the witnesses on this case be excused?
Sure.
Thank you.
All right, next.
Judge, when did you say you needed to turn this in?
Immediately.
Okay.
Yeah. You said I was a threat to society or something like that?
Yes, sir.
So, Mr. Dixon, there's a reason why I didn't say certain things. You explained to me that you have a defense. I would advise you that that it would potentially be in your best interest not to say, or that it is in your best interest not to say anything else since the hearing is over. The reason I didn't say certain things during that hearing is because I want to preserve your defense, and I would suggest that you do that as well by keeping quiet.
Okay,
Also,
well,
Mr. Dixon, I would advise you to make no contact with Miss Jones. Don't call, don't text, don't send word by somebody. Don't have your family call her. Don't have anybody show up. Don't do it on social media. Don't have any contact with Miss Jones. Are we clear?
yes, ma'am.
Okay, because we didn't seem to be clear before, but now I'm hoping that we're clear.
Yes, I understand.
All right.
So I'm excused now, or
The what?
Yeah.
am I excused?
Yeah, y'all work out how you gonna turn yourself in, or you turn yourself in, or you wait to get arrested. That's up to you. But you're excused from this hearing. Yes, sir.
Okay.
All right. Next,
Your Honor, are we waiting?
Mr. McKay. Huh?
I was just gonna ask, are we waiting for Mr. Smith to get to the courtroom? Because the officer on that case is, this is his off day, so he was wondering if it could possibly be sped up a little bit.
Miss Hahn, where's Mr. Smith en route to the courtroom?
Your Honor, I haven't been able to reach him. I've called twice.
All right, so the officers are excused. An arrest warrant will be issued for Mr. Smith's failure to appear in the courtroom as directed by the notice and as directed to him. All right. And so anyone here on Smith, Mr. Smith will be arrested for a failure to appear or a bench warrant because he's failed to appear in court for the hearing. Mr. McKay, are we having a hearing on McKay?
I'm right here. I'm right here. If y'all can't see me, I'm right here. Hope y'all can hear me.
I'm sorry, I missed what Mr. Dixon said.
Mr. McKay said,
Yeah,
I'm right
Mr.
here.
McKay,
I'm
yeah.
right here. Y'all, I'm right here.
Okay. Your Honor, when I was speaking to Mr. McKay in the breakout room, I don't know, because of technical difficulties, that he understands what's going on today. Like I said, this is the first time I've spoken to him. To Mr. McKay today. I didn't have a good phone number for him. And so despite calling the bonding company to get phone numbers, I just didn't have a good phone number for him. So I'm not sure he truly understands what is going on, what's at risk, or I wasn't even able to give him the offer from the state because of his technical difficulties, or convey to him that he may need to come into the courthouse. But so, Your Honor, if we need to proceed on the hearing, I can be ready in the next few minutes, but I'm also ready on Mitchell as well.
Let's go. So like what's going to happen with McKay? So because he has a responsibility to make sure that you have correct information to reach him, he has a responsibility to update the court. So he hasn't done that. And now we're at the point where he's got a motion to revoke, and I'm going to have to delay all these officers who showed up and witnesses who showed up because he doesn't have good tech and he didn't even come into the courtroom like he's supposed to.
I didn't know that.
Your Honor,
because he didn't update his information.
Your Honor, I can't speak to why he didn't update his information. However, since he's here, if we could proceed with the Mitchell case, and then if I could have maybe 5 more minutes to speak with McKay, Mr. McKay, we may be able to proceed with the hearing. I just want to make sure that I convey an offer to him from the state.
All right. This Mitchell, this is a motion to suppress. Is there any Daubert in this?
No, Your Honor.
Jackson Deno?
I'm sorry?
Jackson Deno?
No, Your Honor. It's just
all right. Let's tee up the motion to suppress on Mitchell.
Judge, do we still need the courtroom open up in the deputy?
No, we're good. Mr. Smith is not gonna appear, and if he appears, it'll be taken into custody. All right, Miss Mitchell, raise your right hand for me. Do you solemnly swear, thanks, Deputy. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, so second. Ms. Mitchell, you're before the court on 2023 CR 07024, Dejanay Celine Mitchell, DUI, count 1, DUI less safe, count 2, improper lane change, count 3, and central lane violation, count 4. This is a motion to suppress. You're represented by the law firm of Lister, Holt, and Dennis. Ms. Chelsea Hahn is representing you on this motion, and Solicitor Payne is representing the state. And are we ready to go forward at this time?
Yes, Your Honor.
Yes, Your Honor.
All right.
State your name, Your Honor.
All right. State may call its first witness.
Before we do that, can I ask Ms. Hone to just put on the record what specifically she is asking to suppress and going forward on here?
All right, particularize your motion.
Your Honor, I'm just moving to suppress the blood results in the case.
All right. But there's no Daubert?
Your Honor, it's an implied consent issue or consent issue, Fourth Amendment issue.
So you're not questioning the techniques where GBI is needed, is that correct?
Not at this time, no.
Okay.
All right. All right, state may call its first witness.
So the state would call Officer Flournoy to the stand. And before I proceed, are you, Ms. Hone, then stipulating there's probable cause for the arrest, so I don't have to go through all of that?
I guess I'm not sure if I need to stipulate to that fact on the record. Can you give me just 1 second, please?
Sure.
Sorry, Your Honor, I'm ready to proceed. I just needed a minute to.
That's fine, Ms. Hahn. Go ahead.
So Your Honor, I don't want to necessarily stipulate to the probable cause, but it's not something that we need to address in the hearing. So Ms. Payne, if you wanted to just, stick to the issues that I mentioned in my motion, that's fine. But I just didn't want to stipulate just in case something were to come up during the hearing.
Okay, probable cause at this time, we're moving forward past that point.
Correct.
Then at this point, the state would just call the officer who read the Georgia implied consent, which is Officer Flournoy. I believe that's how you pronounce the name.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. Officer Flournoy, you're before the court on State of Georgia versus Mitchell, and state your witness.
Yes, Officer Flournoy, can you state your name, please?
Officer Esplanori.
Oh, I apologize for mispronouncing your name then. And where do you work, ma'am?
Clayton County Police Department.
And how long have you worked there?
About 3.5 years.
And are you post-certified?
Yes.
Were you post-certified on April 20th of 2023?
Yes.
Were you on duty that day?
Yes.
Did you respond to a DUI investigation to help out?
Yes.
And when you arrived on scene, what did you do?
I stood by as Officer Sergeant Ward finished her investigation. Once she had finished it, I placed the offender in handcuffs, and then I walked her to my vehicle.
Yeah. And when you placed her in handcuffs, did you let her know that she was being arrested for DUI less safe?
Yes, Sergeant Ward did.
Did you then read implied consent to her?
Yes, once we walked her to the car, once I walked her to my car, and then I placed her inside, and then I read her implied consent.
All right. And what section of it did you read?
For under 21, I asked her how old she was. She stated she was 20 at the time, and so I read her implied consent under 21.
And approximately when did you read it?
About the time, probably within 3 minutes of handcuffing her, from walking her from the front of the vehicle to my rear vehicle.
Okay. And was this during the nighttime?
Yes.
And how many times did you read implied consent to her?
Twice.
Why did you read it to her twice?
First, I read for breath. However, the instrument was down, so I reread for blood consent.
And now can you see this, officer?
Yes.
Okay. Do you recognize this?
Yes, it looks like the implied consent card.
Okay. And is it an accurate copy of what you keep in your pocket?
Yes.
Right. Is that the implied consent card that was in effect at the time of the arrest?
I'm sorry, reread. Can you say that again?
Is that the implied consent card that was in effect at the time of the arrest when you read it to her?
Yes.
And did you read it to her verbatim?
No, I changed blood to breath so that way I wouldn't confuse her when I was reading it the first time, and then the second time I changed breath to blood so that way I wouldn't confuse her as far as which test I was consenting for.
So let me ask, you read the implied consent 2 times?
Yes, ma'am.
The first time you read it, you asked for breath?
Yes.
The second time you read it, you asked for blood?
Yes.
Okay.
Okay. And you stated that you designated which test you wanted to run so you wouldn't confuse her. Is that correct?
Yes.
All right. And Your Honor, I'm not really sure how to do this over Zoom, but
share your screen. What is it you're trying to do?
Just admit the implied consent card into evidence. I just don't know how to do that over Zoom.
Okay. Okay. Do we have an issue stipulating to the implied consent card, and then she can she can upload it, the copy that she has, and that'll go to Miss Martin.
Your Honor, no objection, I'm assuming that it's the correct implied consent card.
Okay. Yeah, so you'll just scan it, just have someone scan it, and then we'll upload it and send it to Miss Martin.
I've already scanned it to myself.
Oh, okay. Then share
I
your
just didn't
screen.
know who to send it to. Well, I can open it up and share the screen, I guess, if I can figure out how to do that.
Then there's a video record of it, and I believe Miss Martin also records.
Okay, well, I can try to figure out how to share my screen.
There's a green button at the bottom of the Zoom that says share screen. Choose the yeah.
Okay.
There you go.
Y'all see it?
All right. Is that the implied consent card that you read, Officer Flournoy?
Yes.
Okay, and there's a part that says over 21, age 21 and over, and then there's an under 21 part.
Yes, I read the under 21.
And do you see both of those represented on the screen?
Yes, I do.
All right. All right. So the court will accept the card as exhibit 1 for the state.
Okay. And am I good to stop sharing it now?
I'm sorry.
Am I good to stop sharing my screen now?
Yes, ma'am.
Give me 1 second because the custodial staff is.
Mr. McKay, can you please press mute?
Gotcha, I got you.
I apologize for that. And Officer Lenore, after you read implied consent, what was the defendant's response?
The first time or the second time?
Let's start with the first time.
She said yes.
And the first time you asked for breath, correct?
Yes.
And then the second time you asked for blood, is that correct?
Yes.
Okay, what was her response to you asking for blood?
She said, and then she went directly into asking for her, I believe her dad or her stepdad.
Okay. And after she agreed to blood, did you then take her to the medical at the jail?
Once she agreed, I allowed her to talk to her parents who was on scene, and she also called her dad on the phone. And then once she got done talking to them, I transported to Clayton County Jail.
And
go ahead.
I was just going to ask, when you transported her to the Clayton County Jail, did a nurse draw the blood?
Yes.
And did she tell the nurse that she also was going to agree to do the blood draw?
When she started talking to the nurse, I believe she made a statement and said she didn't want to do it. And then, so she stopped. And before we could start, we was talking to her. I said, okay. And I was telling her her license is about to be suspended. And then she interrupted me and said she'll do it.
And after she re-agreed to doing it, did you then get the blood kit drawn?
Yes.
Okay. Thank you, ma'am. No further questions.
Cross-examination.
Thank you, Your Honor. And is it, I wrote it down, trying to do it phonetically. Is it Flournoy?
You can say Flournoy, that's fine.
Flournoy.
However you want to pronounce it, that's okay.
Well, I'll just say officer for now. So, so you witnessed most of the interaction between my client and Sergeant Ward, correct?
I witnessed the latter end when I arrived to the scene.
Okay. And at that point, when you arrived, you knew it was a DUI investigation, correct?
Yes.
And at that point, about how many DUI investigations had you done
Have I done?
at that point?
I'm not sure.
Okay. But this wasn't your first DUI investigation, correct?
No, and it wasn't my investigation. I was just assisting at whatever Sergeant Moore needed.
Sure. And you've been trained on how to conduct a DUI investigation, correct?
Yes.
Or to assist in one. And part of your training includes how, why, and when you're supposed to read implied consent, correct?
Yes.
Okay. And you're trained that it's important to read implied consent accurately?
Yes.
And are you trained to read it word for word?
Yes, on the card, yes.
Okay. And that's because if you don't read it accurately and the suspect or offender responds, they may be falsely acquiescing to or refusing a test, correct?
Yes.
In other words, they may not understand what they're consenting to, correct?
Are you talking about as far as like reading the card?
Correct. So if you don't read the card correctly, they may not understand what they're either consenting to or not consenting to. Is that correct?
I'm not sure how they perceive it, but as I read it to them, hopefully they can perceive it as I read it.
Okay. Let's see. So the first time you attempted to read implied consent to my client, so shortly after you placed her in the back of the patrol vehicle, correct?
Yes.
Okay. Your Honor, do I have permission to share my screen?
You may.
Okay. Oops. Now, officer, do you see my screen?
Yes.
Okay. I want to make sure I have my desktop as well as the appropriate screen. Do you see the video of what looks like your body camera? Is that what you see on the screen?
Yes.
Okay. And is this an accurate depiction of your body camera from the night of the incident?
Yes.
Okay. Your Honor, permission to admit this as Defense Exhibit 1.
All right, any objection from the state?
No, Your Honor, there's no objection.
All right, will be, the video will be Defense Exhibit 1.
Thank you.
You may continue.
All right. So, officer, I'm going to go ahead and play your reading of implied consent to my client.
Give me 1 second. I'm gonna read.
I just want to make sure you all can hear.
Come to you, okay?
Were you able to hear that?
I can hear it.
You can, Ms. Payne?
Yeah, I can hear it.
Okay, officer, are you able to hear?
Oh, yes, I can.
Okay, I just wasn't sure. Okay.
So I want you to, can you understand me?
Yes,
So,
ma'am.
okay, I just want to read something to you real quick. So you're 20, so I'm reading you implied consent notice for people under the age of 20 years old, okay?
Mm-hmm.
The state of Georgia has conditioned your privilege to drive upon the highway.
Your Honor, it's loading. Your Honor, if I can have a minute to refresh my screen, it's not.
You may.
Thank you.
Dispatch. I don't.
One right now. 20 right now. All right, got you. Give me 1 second. I'm gonna read
I don't
some.
have no, I don't have my license in.
Okay, that's fine.
My mother?
Give me 1 second. I'm gonna read something to you, okay? So I want you to, can you understand me?
Yes,
So,
ma'am.
okay, I just want to read something to you real quick. So you're 20, so I'm reading you the implied consent notice for people under the age of 20 years old, okay? The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to the state administered chemical test of your breath for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.02 grams or more, your Georgia driver license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your breath at your own expense and from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your breath?
Yes.
Okay.
Okay, officer. So at this point in the video, you would only ask my client if she would submit to a chemical test of her breath, correct?
Yes.
Okay. And you admitted the part in the applied consent card that mentions blood or urine, correct?
Yes.
Okay. And at that point, she had only given consent to test her breath, correct?
Yes.
Okay. And as you mentioned before you transported my client to the Clayton County Jail, you read implied consent to her again, correct?
Yes.
Okay. Your Honor, if I may have permission to share my screen again.
You may.
And officer, do you recognize this video that I have on my screen?
Yes.
And how do you recognize it?
That's my hand and my body cam.
Okay. Your Honor, permission to admit this part of the video as defense exhibit number 2.
Any objection from the state?
Wouldn't say I object, but once the video was admitted, the whole portion of the video was admitted, so I don't know if there's a need to admit it again.
Yeah, is there an interim? Is there something that happened between the first part, which was admitted as defendant's exhibit 1, and this part?
I'm sorry, Your Honor, are you asking if there's...
Yeah, if this is a continuation of exhibit 1, then there's no need to readmit. If there was some break in the action where exhibit 1 was cut off and then something happened that we didn't see, and then exhibit 2 is starting at a separate point, that's another thing. But if this is just a continuation of exhibit 1, we're fine.
Okay, Your Honor, we'll keep it as exhibit 1. I apologize.
Okay, thank you.
So we'll
thank you, Ms. Payne. Go ahead, Ms. Hahn.
Okay. And so I'll go ahead and play, officer, this portion. I have to refresh my screen. Give me 1 second. I apologize. Are you all able to see the video again?
Woo! We saw your desktop, but that was a lot.
I apologize, Your Honor. If you all, are you all able to hear?
Huh?
Yes.
Okay. All right.
No, you got to stay inside the car though. So I'm gonna reread you this, and it's just gonna change, okay? The state of Georgia has conditioned your privilege to drive upon the highways of the state of Georgia upon your submission to a state administrative test of your blood for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be used, offered into evidence against you at trial. If you submit to testing and results indicating alcohol concentration of 0.02 grams or more, your driver's license or privilege to drive on the highways of this state may be suspended for one minimum period of 1 year. After first submitting to your required state test, you are entitled to additional chemical tests of your blood at your own expense for qualified personnel of your own children. Will you submit to the chemical state test of your blood? I changed it from breath to blood because our blood machine is down. So it's just for your blood, okay? I think your dad's up.
So, officer, in that portion, you would ask my client if she wanted to submit to a chemical test of her blood, correct?
Yes.
She never said yes, did she?
Well, I heard her say and then go directly into talking about speaking about her dad or stepdad.
So in the video, as soon as you finished reading, you spoke again and then she asked, correct? About her
Yes, I spoke again to let her know I changed it from breath to blood, and then she spoke.
And then she immediately asked to speak with her father, correct?
She said, from what I heard that night, and then went to asking for her dad or her stepdad.
Okay. But you didn't hear clearly from the video, did you? That you just heard?
That I just heard? Well, it seemed like it's still the same thing from the night when I was out there on the scene. It seemed like she was saying, she said, and then she went directly into asking for her stepdad.
Okay.
Or her dad.
Okay. Your Honor, if I could share my screen again.
You may.
Thank you.
For the purpose of determining if you are under the influence of alcohol or drugs, if you refuse this testing, your driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be used, offered into evidence against you at trial. If you submit to testing and results indicating alcohol concentration of 0.02 grams or more, your driver's license or privilege to drive on the highways of this state may be suspended for one minimum period of 1 year. After first submitting to your required state test, you are entitled to additional chemical tests of your blood at your own expense for qualified personnel of your own children. Will you submit to the chemical state test of your blood? I changed it from breath to blood because our blood machine is down. So it's just for your blood, okay?
So, officer, now that you've heard it again, you see that she never agreed to a chemical test of her blood, correct?
Your Honor, at this point, I would object because the question's been asked and answered, and the officer has responded multiple times that she heard the defendant say, and then go in to asking for her dad or stepdad.
Overruled.
So, officer, my question was, now that you've heard it again, you didn't hear her ever consent to a chemical test of her blood, did you?
It might be difficult to hear in the video, but I heard her say, and then she went directly into asking for her stepdad or her father.
Okay. But you heard her previously in the other video say yes to consenting to her breath, correct? The test of her breath?
Yes, and so when I was going to put in my apply insect card back inside my vest, you heard a little shuffle. That shuffle could have been mistaken. They could have heard her clearly, but I know I heard her say and then go directly into saying, asking for her stepdad or her dad.
Sure. Okay. And later you transported my client to the Clayton County Jail. And you met with the nurse there, correct?
Yes.
Okay. And then again, she asked if she had to have her blood drawn, correct?
She was speaking to the nurse. I believe that's what she said. And
Okay.
then as I turned around, I explained to her, okay, if you don't, well, your license will be suspended. And as I was going to get ready to walk out, she interrupted me and said she'll do it. And that is when the nurse proceeded with it.
Okay. And while you were in the room where the blood draw was to take place, you told her that she had already consented to a blood draw, correct?
I told her, I don't remember saying that exactly like that, but I do remember saying, like I said, your license will be suspended. And then she interrupted me and said she'll do it.
Okay. All right. If Your Honor can have a moment, I'll share my screen again.
Any type of, legal advice actually as long as they have your blood. Okay. Not going to jail ever? Like I explained to you, I read you the card, implied consent card, you agreed, but now you're refusing, so the license will be suspended. It's up to you, it's your decision.
Oop. So officer, at that point, you said, quote, like I explained to you, I read you the card, implied consent card, you agreed, but now you're refusing. So your license will be suspended. That's what you said, correct?
Yes.
Okay. But she never agreed to a chemical test of her blood, did she?
Like I stated earlier, I heard her say and then go directly into asking for her stepdad. So when she said I took that as an agreement. She never defied or anything like that while we was standing there talking on the side of the road.
But it was clear that she agreed to a blood test, a breath test, correct?
Yes.
Okay. And officer, it's true that you can apply for a warrant to search for my client's blood, correct?
I wasn't the arresting officer, so I don't have that privilege.
No further questions, Your Honor.
All right, I have a question that nobody seems to be asking. Why, when you get a consent for breath, did you read implied consent again and change the test?
The instrument was down at the time. We was using Jonesboro Police Department and tonsilizer. However, the instrument was down. So once I found out, I reread for blood.
All right, any other questions?
None from defense, Your Honor.
I have a question, Your Honor.
Uh-huh.
Officer, so you testified on direct and on cross that you heard the defendant say to your reading of the implied consent asking for blood. Is that correct?
Yes.
And you testified to the fact that you even hear it on the video. You just can't hear it as well. Is that correct?
Yes.
Are the ears that you had on scene that night going to be able to hear more of the defendant's statement than the quality of the video that we have from all the background noise?
Yes,
Are you sure that, she did give consent to, her blood drawn?
yes.
Um, thank you. No further questions.
All right, anything else for Officer Flournoy?
Nothing from the state.
All right, anything else from the defense? At this time, may this officer be excused?
Nothing else from defense, Your Honor.
The officer may be excused. I do have, one more witness though, Your Honor.
Okay, yeah. The state may present its next witness. Officer, you're excused at this time. Thank you.
The state would call, Miss Sharon Brown to the stand.
I'm here.
All right. Ms. Brown, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. You can put your hand down. You're before the court of State versus Mitchell. You are here on behalf of the state. Ms. Payne, your witness.
Yes, Your Honor. Ms. Brown, can you state your name, please?
Sharon Brown.
And where do you work, Ms. Brown?
I work at Clayton County Jail.
And what is your job capacity there?
I'm the Health Services Administrator.
Do you supervise, and maintain the record of the nurses that are on staff at the jail?
I do.
The procedure that your nurses have there, to the best of your knowledge, do all your nurses follow it to the best of their ability?
Yes, ma'am.
If a defendant is brought in on a, implied consent blood draw, will the nurse draw the blood if the defendant then refuses and says, no, I don't want the blood
No, they
drawn?
will not.
Is it against policy to draw the blood if the defendant actually refuses it?
No, we cannot do that. No.
So you have a
A
policy that,
policy, yes, yes. We
Okay.
cannot force anyone to do anything, right?
and you said to the best of your knowledge, your nurses comply with that policy?
Yes.
Are there repercussions if the nurse does not comply with the policy?
Yes.
What's the repercussion?
You cannot force anyone to do anything, even take medications or anything. If so, you can lose your license. You cannot force them. Yes.
And to your knowledge, Natalie Chance, the nurse in this case, her license is still valid?
Yes.
Thank you, ma'am. No further questions.
All right, cross-examination.
Yes. Ms. Brown, when did you start working as a nurse supervisor?
About almost 2 years, not quite, like a year and 8 months.
Okay. Do you remember your start date?
November 7th, 2022.
Okay. All right. Nothing for this witness, Your Honor, or nothing further for this witness.
Okay. All right.
There is no redirect, Your Honor. This witness may be excused.
All right, Ms. Brown, you're excused at this time. Thank you.
Thank you.
All right. Any other witnesses for the state?
Since Ms. Owen stated all she was attacking was the implied consent, no, there's no other witnesses. State would rest
All
at this
right.
time.
Any other witnesses on behalf of the defense?
No, Your Honor, I would just ask for about a minute or two, for argument. I have my argument. There was an issue with my printing, so I just need to pull up my bullet points, if that's okay.
All right.
Thank you. Right, Your Honor, I'm ready. I apologize.
All right, go ahead.
I'm sorry, is it the state is reserving?
That's correct. I'll just reserve the right to.
Okay. So Your Honor, under US and Georgia law, this requires that a search of my client's blood be performed with a warrant, but absent a warrant, an exception to the warrant requirement should apply. The state's contention is that the warrant was not required under these circumstances because Ms. Mitchell consented to the search of her blood. However, Ms. Mitchell never consented to the search of her blood. The state conducted an unlawful search of my client's blood in violation of Fourth Amendment rights, and any evidence obtained from that search should be suppressed. As the court saw in the video, first implied consent was read by Officer Flournoy, but only as it concerned my client's blood. My client, as the court heard, gave a loud and clear answer that she would consent to a search of her, of her breath. She gave a clear answer that she would consent to a search of her breath. However, when Officer Flournoy came back and read implied consent as it applied to her blood, my client did not, it's our contention that she did not consent at all. We believe that as soon as the officer finished reading implied consent, she didn't even give space for my client to respond. She immediately said, oh, well, I just had to, and this isn't a direct quote, but I had to reread it to you because it's for your blood. Didn't give my client time to respond after asking if she would consent, just corrected herself. And then my client, as you saw in the video, kind of stared off a little bit and then asked to speak with her father. She never gave a consent to her blood. And then again, when she was in the room with the nurse for the blood draw, she showed again that she did not want to consent to her blood. There was a clear consent to giving a test of her breath, but never to her blood. In that case, officers should have applied for a warrant for her blood if they wanted to get her blood. Furthermore, it is State v. Henry, believe that says that in order, when there is any ambiguity, which we don't believe that there is, that the ambiguity should be construed in the driver's favor. And so, Your Honor,
what's the site?
Pull up for you, Your Honor. State v. Henry. Why does it say that? Sorry, Your Honor. That's what I was trying to pull up before I. Let's see, Your Honor, it's 36, I think it's State v. Henry, Georgia. I'm sorry, Your Honor, I can't find the site anymore, so I apologize, Your Honor. I'll just withdraw that from my argument. But nevertheless, Your Honor, implied consent was not read properly. My client never consented, as we saw in the video, and therefore we believe that the chemical test of my client's blood and any evidence that came from it should be suppressed.
All right, State.
Yes, Your Honor. The state would contend that the officer did do as the law allows for implied consent, even in the implied consent statute for OCGA 40-5-67.1 and B right under 3, it doesn't have a number listed by it. It says, if any such notice is used by a law enforcement officer to advise a person of his or her right regarding the administration of chemical testing, such person shall be deemed to have been properly advised of his or her rights under this code section and under code section 40-6-392, and the results of any chemical test or the refusal to submit to a test of such person's blood or urine shall be admitted into evidence against such person. Such notice shall be read in its entirety, but need not be read exactly so long as the substance of the notice remains unchanged. The officer did testify that the reason she asked for breath and then blood is so that the defendant would not get confused about which test she was specifically requesting for. In addition, Eberly v. State, which is 240 Georgia Act 221, actually states that a refusal to take a state administered chemical test since could be admitted since there was substantial compliance with the implied consent notice informing defendant that he was entitled to secure additional testing. So not having it just read verbatim is not a strict law to get the implied consent and the bloods out, because the purpose of the law, and even in the legislature purpose, is that the defendant be have a substantial understanding of what is being asked of him or her and what is being required.
Okay, so this is my concern, Ms. Payne, because even the way that the current case law trend, it initially kind of like treated breath and blood somewhat differently, but it's trending to give more deference for both tests. But here's the issue. So we're hearing the first consent being read in its entirely. She's asked for breath. She agrees. Then the officer comes back almost immediately, reads it again, asks for blood, and at that time, she's distracted. She's talking to someone else, but there was no distinction made that, hey, I'm not just rereading this to you. The test is changing, and it was like back to back. So if she agreed to breath, then there should have been no need to read another test. But if she's going to read the other test, there was no information given to the defendant that, hey, I'm reading this test. I'm not asking you for blood this time. I'm asking for breath because there was an issue. Not that in the compliance issue, like I'm reading the same card. It's the same information, but the test issue, because the way the tests are treated under the state is a little bit different, but also you're asking someone not to just blow into a tube, but you're asking someone to submit their arm to be punctured by a needle to get a test. So in that sense, I'm asking because this is the first time I've had a case where the implied consent is completely read for one test and then it's completely read again for another test. And so my issue is, if she agrees that she's willing to take a breath test, that agreement is different than if she can fully agree, hey, I'll be fine to blow into a tube. But she can also say, yeah, but I'm not cool with that blood. And so when an officer makes a decision about what test they're asking about, I'm not clear that she was clear that there was a change from, yeah, I'm agreeing to blow into a tube to, yeah, I'm agreeing to let you puncture my arm and take blood.
Your Honor, the state would contend that the officer did testify, and you even saw in the video that at the end of her reading implied consent, she actually stated that the only thing I'm changing is now I'm requesting blood and not breath. So the state would contend that the defendant was put on notice and was aware that she asked for blood and not breath, because she repeated it multiple times within that implied consent warning and then said, I'm just asking for blood instead of breath. The state also contends that when the defense even showed her at the nurse's office that, or that at the jail, that she was getting up ready to give blood, and that to also testify to, when she was talking to the nurse, she said, I didn't want to do it. And I was like, okay. And then re-explained, well, I read implied consent for blood. You had done agreement and now you're refusing, and that's fine. It's your choice. So,
I get that, but before she says it's your choice, and the part that nobody mentioned is I heard a conversation going on where someone mentions jail. And I didn't know because of the quality of the video, I didn't know if that was Miss Mitchell asking about whether she was going to jail or whether the nurse discussing jail, but I heard jail. And then right after that, it was the discussion of, well, if you don't want to take the test, then your license is going to be suspended, but it's up to you. So in other instances, the fact that the license suspension part is restated once a person initiates a refusal can be seen as being somewhat coercive.
The state would contend that after you just said it's up to you, that there's nothing in the case law that says that it is coercive, and that Jackson v. State actually just says it's a totality of the circumstances of involuntary consent, and that her initial agreement to it can lead to it also designating it as voluntary, and the fact that she was aware that she could refuse it, that she was aware that there was no threat or of anything, and there was no threat of lengthy detention or anything like that. It was just, the state's contention on that was she was already at the jail. She was already in the position of she knew she was going to jail. It's not like she was thinking that this would now get her out of jail, because that was never promised to her. She was sitting in jail with the jail nurse. The Miss Brown even testified to that the policy of that is if they refuse and they say no and they don't want to do it, we can't do it. We don't do it here, because that will make our license suspended. She testified to that Natalie Chance, which is a nurse on the case, license is current. So there was no refusal in this case, and she was aware of her what test was asked of her, and she was aware that she could have her own other chemical test done or she could refuse it, and she chose to let the nurse draw her blood.
Last thing, no ma'am, Miss Mitchell, what is the substantial difference between the over 21 card and the under 21 card that was read in this case?
The over 21, the only difference is that it will say 0.08 grams, and the under 21 says 0.02.
All right. Miss Payne, did you have anything else on behalf of the state?
No, Your Honor.
All right. All right. So the court is going to take this under advisement, and we'll issue a written order so that you all may proceed from that point. All right. Thank you all. Ms. Mitchell, the reason I said no, you can't say anything is because you have the right, the Fifth Amendment right against self-incrimination. I do not want you to mess up your defense. Anything that you need to discuss, please discuss it with Ms. Hahn. Ask her any questions that you have about this hearing or about anything in this process, but please don't disclose anything to anyone else other than Ms. Hahn as part of your defense, okay?
Your Honor.
All right. Thank you, ma'am. All right. You're free to go at this time.
All right. Thank you. Have a nice day.
All right. You too. All right. And my understanding is we have one more, Mr. McKay.
Yes, Your Honor. And then I had asked if the court could give me just maybe 2 to 3 minutes just to make sure that he understands what's going on, because prior to now, his communication.
Y'all need a breakout room?
Yes.
Okay. Is Mr. McKay, is he still on? Yes, Mr. McKay, I'm going to put you in a breakout room with Ms. Hahn. She's in breakout room number 2, I believe. And you can go in there and speak freely with Mr. McKay. And I'll be right back.
Thank you, Your Honor.
Welcome. Mr. McKay, if you touch your screen, the invitation to go into the breakout room should pop up. When you touch that invitation, touch that blue button, I think, then that will take you into the breakout room with Ms. Hahn so y'all can have a private conversation.
Your Honor.
Yes, ma'am.
I'm just waiting to see Mr. McKay here before I make my announcement. I've asked him to leave the breakout room.
Okay.
There he is. Okay. So Your Honor, I have, as I mentioned before to the court, this is my first time speaking to Mr. McKay. He's indicated to me through our conversation that I'm not sure he truly understands the scope of, not necessarily the scope, but what's happening. I've tried to explain to him that today is a hearing for the motion to revoke bond in his case, and that the state has filed a motion asking to revoke his bond based on the fact that there's been a subsequent arrest. And I've also conveyed the state's offer to resolve the cases to Mr. McKay. I believe, and I'm not saying this confidently, but I believe that Mr. McKay wants to move forward with the hearing because he's indicated to me that this time he doesn't wish to accept an offer from the state. But I wanted to address the court because I told the court it would only take about 2 to 3 minutes, and I'm just not sure he truly understands, and I just don't know if I have enough time to explain it to him.
Okay, let me ask you a couple questions. Is this a technology issue, or is this Mr. McKay has some cognitive difficulties I don't know about? What's going on?
Your Honor, it's primarily a technical issue. We did talk on the phone.
Well, then he could have been here an hour ago in the courtroom.
Your Honor, I don't think I was able to communicate that to him until, or
I
just
spoke to Mr. McKay a couple of times, so I don't know how I could have talked to him on the in front of everybody, and made myself understood. But you couldn't tell him get in your car and come to the courthouse. Get an Uber, come to the courthouse. You could have sent him a text message. You could have sent him a chat. You could have called him, told him. I mean, all of this, I don't understand. I don't understand. I can make it clear if you're in the courthouse.
I understand, Your Honor. We just exchanged phone numbers.
Well, that's the problem. Mr. McKay is slacking because he has a case pending and he hasn't updated the state, which is his responsibility. He hasn't updated his attorney, which is his responsibility. And so now you want me to make accommodations for Mr. McKay, accommodations that he's not entitled to because he hasn't done what he's supposed to do. If it was a failure of notice on our part, be more than willing to say, hey, let's rewind it and start again. All these witnesses you brought today, the fact that we're all ready to go forward, then, too bad. We didn't do what we were supposed to do, but I don't have that. So, Mr. McKay,
I rather talk, Your Honor. I can talk because I can talk because I don't know why she keeps saying she don't know. That ain't what I'm saying. You feel me? That ain't what I'm problem.
Mr. McKay, no, I don't feel you. Mr. McKay, we're ready to go forward.
That's what I'm saying.
I'm not sure what's going on.
I called the bonding company and updated my information. That's how you found out I got caught.
The bonding company, that's separate from the court. The bonding company is the people who allowed you to bond out. The people who send you notices for court and let you know what's going on, that's the court. So if you don't tell us what's going on, we're sending it to the address that we have on record. So if you just gonna tell your bonding company, that's you and the bonding company, they don't work for us.
I got you, man. But I rather have a hearing.
Get in a room where I can see you. Turn a light on or go outside or something.
This on the only spot I can be wrong.
Just who, what, and what?
I say this the only spot I can be like right here. I got bad service. That's why it's hard for me to talk to y'all.
Go pull up a chair and sit right there. Go get a chair, Mr. McKay, because you're going to be here a minute because we're about to have a hearing.
I'm sitting down.
No. You about to have a hearing. Get a chair, sit right where you are.
I'm sitting, man.
All right. Raise your right hand for me. solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. So you're before the court on a motion to revoke bond. That means that you have done something to violate your bond conditions that were initially set when you were arrested. And the state is wishing to have that bond revoked, and you'll be jailed until such time as your case is tried, if the court decides that you have, in fact, violated your bond conditions. You're represented by Ms. Chelsea Hahn. This is case 2022 CR 01518. Simple battery, family violence, count 1, simple battery, count 2. Is the state ready to go forward on this case, on the motion to revoke bond for Mr. McKay?
Yes, Your Honor, the state's ready.
All right, state may call its first witness. Mr. McKay, I would advise you to remain silent. You have that right under the Fifth Amendment of the Constitution, but you also don't want to mess up your defense. And so anything that is going to be presented on your behalf, Ms. Khan will present for you, okay?
Okay.
All
Yes,
right.
ma'am.
All right, Ms. Payne, call you first.
Your Honor, before I call my first witness, the state would just like to request that the court takes judicial notice of his order for bond that was dated May 25th of 2022. Signifying that he was to stay away from Shamika Cargill, not return to 1509 Fairway Point, and not commit any new laws while on bond. And for the first witness, the state would call Officer Jesse Kearney.
Okay, Officer Kearney, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. State's witness.
Yes, officer, can you state your name, please?
Officer Jesse Kearney,
Where do you work, sir?
Clayton County Police Department.
And how long have you worked there, sir?
2 years.
Did you work there back on May 12th of last year?
I did.
Were you on duty that day?
I was.
Did you receive a call from dispatch that day?
Yes, I did.
And did you respond to 1509 Fairway Point Drive?
That's correct. Riverdale, Georgia.
Is that in Clayton County, sir?
That's correct, ma'am. It's in Clayton County.
And who did you make contact with when you arrived on scene, sir?
The first time I made contact with a Mr. With the victim, which was Miss Samari V. Penham.
I apologize. And what did she say to you when you made contact with her?
Originally, she said that the defendant had mashed her in the face, and there were no visible marks.
And did she state what happened after the defendant mashed her in the face?
Yes, ma'am. He said then the offender grabbed her by her right wrist with his left hand, leaving visible wounds on the victim.
And were you then able to make contact with the defendant?
Yes, I was.
What did he tell you?
Originally, he said he didn't even know who the victim was. And so, but then I, began questioning him, and then I had her to come back to the scene. Once she came back to the scene, that's when everything started coming together, and then that's when the whole case really just unfolded.
And when you say that you had her come back to the scene, where did she go?
She had went over to 50 Drew Court.
And where was that in relation to where the scene was?
There's probably about a quarter of a mile in nautical miles, but it was probably about a mile and a half. Same neighborhood, but just a different location.
And why did she leave the scene when after you made contact with her?
Originally she said she was just wanted to get away. But then once I had her come back, because I was like, hey, I need to investigate it. And she came back. But like I said, once she came back, the offender, he really just changed his whole story. And then he went into saying, yeah, I know her, because he was trying to protect her from going, I guess, protect her from something. He didn't ever say what he was trying to protect her from.
And did the victim say how they knew each other?
Yes, ma'am.
Well, how did they know each other?
They were dating, and then she was staying with him, and she had clothes there. That's why she was trying to leave.
All right. And during your investigation, did you see evidence to corroborate the defendant's side of the story? Or did you see evidence to corroborate the victim's side of the story?
I did. Explain that for you. What are you talking about? What you're saying, man? I'm sorry. I don't
During your
understand.
investigation, you said that the defendant's story changed after the victim returned back on scene. Did you see any evidence to corroborate his side of the story?
No, ma'am. It was just mostly hers. Her side of the story. I mean, it was to say that he didn't know her, but then once he got there, it was blue. You know, like they really knew each other and they was in a relationship. And he started telling her that I'm gonna let you come back. I'm gonna let you come back. I'm gonna let you come back. And she was like, I just want to get my property and get my stuff out.
And at the end of your investigation, did you decide to take out a warrant on the defendant or to arrest the defendant?
I arrested him on site.
What did you arrest him for, sir?
Battery, family violence.
And why did you arrest him for battery, family violence?
Because of the relationship that they did stay and live under the same roof at a certain time.
And you stated you were able to see a visible injury to her wrist. Is that correct?
Yes, ma'am. I have attachments. It's attachments where you can visibly see that she does have injuries to her. I think with her right wrist or left hand in the report.
And do you see the defendant on the Zoom platform today that caused that injury to Miss Penamon?
Yes, ma'am.
Can you identify him, please?
Yes, ma'am. He's he's on my screen. He's in the top right hand corner. He's a black gentleman with a low haircut, and there's a white wall behind him with a black shirt on.
Thank you, sir. No further questions.
Cross-examination.
Yes, Your Honor. First, Officer Kearney, you didn't see anything. I'm sorry, I don't know what that was. Officer Kearney, you didn't see anything that happened that day, correct? You just arrived afterwards?
Yes, ma'am.
Okay. And when you questioned my client, he mentioned to you that he didn't put his hands on the alleged victim. Is that correct?
Yes, ma'am.
Okay. And my client stayed on the scene the entire time, correct?
Yes, ma'am.
Okay. But the alleged victim left.
Yes, ma'am.
Okay. You mentioned that my client, or you thought that my client was trying to protect her, correct?
That's what he said, ma'am. It wasn't that what he said.
Okay. So it's possible that she could have been the initial aggressor in this situation, correct?
No, ma'am. Because originally I was called out for a theft of property, and the property was a gun. So, to say that, you know, someone has stolen your gun and then you're the primary aggressor would be kind of backwards.
Well, you said she said that, but you're not
No,
sure
ma'am. I was
that
dispatched.
happened.
No, ma'am. I was dispatched originally to a theft of property, and the theft of property was a gun. That's what I got.
Right.
Once I got there and started my investigation, it was later determined that it was a battery, family violence.
But you're not sure, just because you were dispatched to something, doesn't mean that that's what actually happened, correct?
Well, ma'am, we got to go with dispatch now. We got to go with what's being said and what's been turned over to us. Your investigation will later turn up what really happened.
So in that case, is it also true that it's possible that my client was also telling the truth? If we believe dispatch, then we can also believe my client, correct?
Well, ma'am, did your client call dispatch? I don't think your client called you. It was the witness who called dispatch saying that my gun had been stolen by someone. So if you're reporting to a scene with a gun, it's totally different.
Right.
Correct?
But the dispatch officer wasn't there. My client was, correct?
Yes, ma'am.
Okay, I'll move on. And you mentioned that my client was kicking the alleged victim out of the house, correct?
Yes, ma'am.
Okay. All right. So it's likely that she was upset about that, correct?
I can't say if she was upset about that or not. That would be something to ask her, ma'am.
Understood. All right. All right, no further questions for this officer.
All right, any redirect?
No, Your Honor.
All right, may this officer be excused?
Yes, Your Honor.
All right, Officer Kearney, you're excused at this time. Thank you for your patience.
Yes, ma'am. Thank you so much. Have a good day.
You too. Does the state have additional witnesses to present?
Yes, Your Honor, the state would call Ms. Sumaro Penaman to the stand.
Ms. who?
Sumaro
Oh,
Penaman.
okay.
Hello?
All right, ma'am, oh, there you are. Raise your right hand for me. Okay, sit down somewhere and be stable. All right, do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Your witness.
Yes, can you state your name, please?
Samara Penniman.
And do you know the defendant, Ms. Penniman?
You know what?
You know Mr. McKay?
Yeah,
How do you know him?
we dated.
Right. Did you once reside with Mr. McKay at 1509 Fairway Point Drive?
Yeah.
And on May 12th of last year, did you have reason to call 911?
My property was stolen, and we got into a little altercation. But after that, yeah, my property was stolen, and we got into a little altercation.
And what do you mean by a little altercation?
Like, pushing and shoving. That's it. But not too much. Not too much like heavy beating or nothing like that.
And so did the defendant push you that day?
Yeah.
Did he also grab your right wrist?
Yeah.
Did you get a scratch mark on that wrist due to him grabbing you there? Ms. Penman, did you get a scratch mark on your wrist due to him grabbing you there?
Yes.
And did you then report this to a 911 officer or a law enforcement officer?
Yes.
And thank you. No further questions. Or do you see the man who left a visible mark on your wrist on the Zoom platform today, although his screen is not up?
Yes.
Mr. McKay.
Mr. McKay, you got to come back to the hearing.
I'm in the hearing. Y'all can see me.
You went away for a minute. All right, go ahead.
Can you identify him, Ms. Penman?
Yes, he got a black shirt on.
Thank you, ma'am. No further questions.
Hold, give me a second.
Hello?
There is no further questions from the state.
All right, cross-examination, Ms. Hahn.
Yes, Your Honor. Ms. Penniman, you thought my client stole your gun that day, correct?
Mm-hmm.
And he was kicking you out that day, correct?
Right.
And that was upsetting to you, correct?
It wasn't upsetting until my property got stolen, and I couldn't take it with me.
Sure. And so when you thought your property was stolen, you came at him wanting to get your gun back, correct?
No. I mean, we argued about it for a little minute, but when I see I couldn't get nothing out of it, I just went home.
You started that argument, correct? Because you thought he stole your gun?
No, I ain't started no argument.
So you approached him
We was
accusing him.
already arguing.
Okay.
We was already arguing because he was putting my clothes out and he was putting my stuff out. So we was already arguing. When I seen that I couldn't get my gun, it got intense, but I went home.
And you have the gun now, though, correct?
Yeah, I got the gun now.
Okay. You found out later he didn't take it, correct?
He didn't take it.
I'm sorry, what was that?
I said he did take it. He ended up giving it back to me.
All right, no further questions, Your Honor.
All right, any other witnesses for the state?
No, Your Honor, and this witness may be excused.
All right, Ms. Penniman, you're free to go at this time. Thank you for your patience. All right, does the defense have any witnesses to present on behalf of Mr. McKay?
Your Honor, Mr. McKay, before we got cut off, technology-wise, he let me know that he may want to testify. If I could just confirm, Mr. McKay, are you sure that you would like to testify against your Fifth Amendment privilege to remain silent? Or do you need a moment?
What, to tell my side of the story?
All right, so Mr. McKay, listen up carefully. You have the right to remain silent. You do not have to give any evidence or testimony in this case. Nobody can make you testify. Nobody can promise you anything to get you to testify. Nobody can threaten you and cause you to do so from a negative standpoint. They can't offer you anything from a positive standpoint. You have the right to remain silent. It is the state's burden to prove the case against you beyond a reasonable doubt. But if you choose to give up your right to remain silent and offer testimony, if you choose to give testimony in this case, anything you say can be used against you in this and any subsequent proceeding, which means that anything you say today could be used in your plea or trial on any pending case that you have. Do you understand that?
Yeah, I got you.
All right, so
I understand.
You wish to give testimony?
No, I'm gonna remain silent, y'all. I just remain silent.
All right. So, Ms. Hahn, did you want to verify that your client said he chooses not to testify at this time?
Yes, Your Honor, Mr. McKay, just on the record, you and I discussed that at one point that you thought it was important to share your side of the story. However, you're choosing at this point, is our understanding in front of the court, that it's in your best interest to remain silent. That means that I will not be asking you questions about what happened in either incident at this time in this motion to revoke bond hearing. That means also that Ms. Payne or that anybody from the state is not going to cross-examine you at this point in time regarding what happened in this incident. And it's your decision at this point that you do not wish to testify in this motion to revoke bond hearing, correct?
No, I ain't going to testify. I can't. What can I say?
Okay. All right.
I understand y'all.
Okay.
All right. So you said you're not going to testify. I'm going to ask you at this time to remain silent so that you don't give up your right to remain silent accidentally. All right. So is the state going to present any other testimony?
No, Your Honor, the state would rest at this time.
All right. Defense?
Nothing, Your Honor, from the defense.
All right. So argument?
The state would just reserve the right to close, Your Honor.
All right. Ms. Hahn?
Your Honor, it's our contention that on the date of the incident, Ms. Penniman called because she at the time believed that our client had stolen a gun from her. Our client has not been convicted of a theft, for stealing a gun. So it's our contention that that didn't happen at all, that she was upset about him kicking her out of the house and decided to call the police. The officer that testified didn't see anything that happened that day. He testified that he took the word of the dispatch officer, who was also not there, and decided to weigh the word of the alleged victim heavier than my client. It's our contention that our client didn't commit a wrongdoing that day, and therefore didn't violate his bond, in the sense that our client is not a danger to the community as well. As Your Honor can see, that despite us not having communication with our client, he did appear here in court today. So we also contend that he is not a flight risk, and that he would appear in further court hearings, even despite direction from counsel. So Your Honor, I believe at this
Well, I
time,
mean, I'm looking at a spaceship right now. I'll need you to stay on, Mr. McKay. All right, go ahead.
Your Honor, so it's our contention is that at this time, we don't believe it's appropriate to revoke the bond of Mr. McKay. And also, Your Honor, just going back, differentiating Mr. McKay's case from other cases where there's been a pervasive history with the same alleged victim, this is not the same victim in the case that is on the calendar today. This is a completely different person, completely different situation. And so, Your Honor, again, for that reason, we don't believe that Mr. McKay is a danger to the community. And in that way, we do not believe that the state has met its burden of proving so.
All right. Ms. Payne?
Yes, Your Honor, the state would contend that I have met the burden to show that Mr. McKay has violated his bond by getting the new charge of battery family violence. And you did hear the officer testify to the fact that the initial call was for
Ms. Payne,
a gun.
I'm not getting clear.
Oh, I'm sorry. You did hear the officer
Testimony.
testify to the fact that dispatch told him that he was responding to the theft of a gun. When he got there, he made contact with the victim, Ms. Pinamon, who stated that yes, she did originally call because the defendant did take her gun. And she knows the defendant took her gun because the defendant gave it back to her later on. You also heard her say that he pushed her and then grabbed her wrist and caused a scratch mark on her wrist. And he was the one who was starting the altercation by throwing all her clothes out when he had no right to do that. And you heard the officer testify to that when the victim had left the scene to just walk away and not wanting to be on the scene anymore, to walk away from the trouble, that Mr. McKay actually said that he didn't know her and lied about that. But then when she returned back on scene, he then admitted to knowing her and changed his story because he couldn't lie anymore. The state would contend that this case is very similar to the case that he's out on bond for, because the case he's out on bond for is simple battery family violence. And yes, it is with a different victim, but that's actually concerning as well, considering that the point of a bond is the court has to determine that he's not a threat to anyone in the community. That involves anyone, not just the same victim. And what he has shown is that he gets arrested for multiple victims at the same location, and poses the risk of keep violating the law. So the state would ask that you do find that he has violated his bond by catching a new charge of battery family violence to Ms. Pinamon and revoke his bond. Thank you.
All right. Oof. What's the previous charge that Mr. McKay was on? Also, battery family violence.
The previous charge is actual simple battery family violence. The victim in that one is Ms. Shamika Cargill. And that was from what's the date? December 31st of 2020.
Has he had any additional charges since May 21st of 2023?
Just a second, I'm checking.
I'm sorry.
I said just a second, I'm looking at his criminal history. No, Your Honor, he is not.
Okay, and I'm sorry, you were looking, I should ask this before. So between the time that he was arrested for the initial case in 2021 and 2023, did he have any other, well, I'm sorry, 2022, did he have any other issues?
I believe he has a failure to appear in a probation violation that were in between those two, but no other things.
Okay.
I got what?
Hold
Mr.
on.
McKay, please be quiet.
So, Mr. McKay, stop. So at this time, the court is going to decline to revoke the bond. However, I will reiterate to Mr. McKay that your bond conditions require that you not have contact with any of the victims on the two previous cases. I think that Mr. McKay, in my opinion, was trying to do what is called a self-help eviction. And in doing that, there was an altercation with the individual who was staying in his house at the time. Not that it makes it better, but I don't see that it is a pattern of, I'm not seeing the pattern of violent behavior that would lead me to believe that he's a danger to just about anybody. But Mr. McKay, two things. One, you need to update your address with the court, not your bond company, because we don't deal with the bond companies, you do. We need to have your address corrected with the clerk's office, the state court clerk of Clayton County. In addition to that, you need to always have a correct number and address on file with your attorney's office so they can always reach you. Number three, I need to reiterate that you have bond conditions in place, and I need you to listen to me carefully. If you do not understand, when I finish talking, I'm gonna need you to ask me some questions. The first thing is you have bond conditions that require you not to have contact with particular individuals, Ms. Shaniqua Cargill and Miss Samara Penniman, not to have any contact with them. Don't call them, don't talk to them, don't do social media, don't have a friend reach out to them, nothing. And don't go to any locations that you're prohibited from going to. Let me just remind you that if you were to violate your bond conditions, your bond could be revoked and you could spend the rest of the time in jail until one or both of your cases are resolved. Number one. You could also be charged with the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both. Or you could be charged with a misdemeanor, which is punishable by up to 12 months in jail or a $1,000 fine. Or all three of those things could happen. Do you understand?
Yes, ma'am.
Okay, do you have any questions about what I just said?
No, ma'am, I understand. Stay away from the police.
If you have any questions about what's going on, if you don't understand in any way what I have said, what I want you to do is get a copy of your bond conditions on both bonds from the clerk's office, read them carefully, have somebody explain anything to you that you do not understand, but until such time as your trial date, you're not to have any contact. And the most important, you're not to pick up any more charges, Mr. McKay.
I got you, ma'am. I got you. I've been working on that. I really have.
The only thing that keeps me from revoking your bond is I see from experience the difference in these two cases, not that one is less than the other, but it is a different behavior in each of the cases, which has told me that even though you picked up another charge, it's not the same as the previous one. So what I'm going to ask you to do is not have any contact. Don't room with nobody. Keep your nose to the grind until you get these cases resolved in whatever way y'all resolve them. But please don't pick up another charge, because if you do, you'll come back for a revocation hearing, and then you'll have 3 cases. And at that point, I'm not going to be as lenient.
I got you, ma'am. I understand.
All right.
Judge, just real quick before he logs off, I was just informed by the officer that he is wanted right now for a county ordinance. So
it's a county ordinance. Mr. McKay, talk to your attorney about coming in on the county ordinance. County ordinances are punishable by up to 6 months in jail, a $1,000 fine, I think. So come in, talk to your attorney, come in, get the county ordinance thing worked out, because you probably missed a court hearing just like you missed one for us. You gotta get your address changed.
I got you, ma'am. I got you. So did my attorney right here, did the one I can get in touch with on the case that we're talking about?
Yes, sir, but she gotta know how to get in touch with you. You can't just change addresses, change phone numbers, and then forget that you need to talk to somebody about your case. All right, so there is a warrant for your arrest for county ordinance. You need to get on top of that and handle it before they arrest you.
All right, I got you. I got you, ma'am.
Thank
you, Your Honor.
All right. All right. Anything else at this time? Thank you all for your patience. I know it was a kind of a long day. But thank you. And Ms. Payne, thank you. You gonna be assigned here, or are you kind of switching in and out?
I was just pinch hitting for today, Your Honor.
Okay. All right. All right. Thank you so much. Good